Demons has counseled assist the attorneys with this gentleman's jury. Sorry it took so long, that's my fault. But we're ready to start now. So when we broke yesterday, state arrested their case, and now you're involved in this now?
Yes, sir. We're going to call Adrian Davis.
Adrian Davis, please. Mr. Davis? Are you Mr. Davis?
Oh, yes, sir.
Welcome. Come on up here. This is our witness stand. When you get there, just remain standing for a bit. Raise your right hand. Be sworn.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your full legal name for the record.
Adrian Davis.
Please spell your first and last name for the court.
ADRIANDAVIS.
Thank you, sir.
Please have a seat. Mr. Davis, that microphone in front of you will adjust up or down, but does not move back and forth. Okay, you ready to go?
Yes.
Counsel, you may proceed.
Good morning. How old are you?
24.
Have you ever been convicted of a crime?
Objection,
No.
Your Honor, improper bolstering.
Thank you. I need to know an answer. Come sidebar.
Do you have a nickname?
Yes.
What is it?
AD.
Okay. First of all, take your hand away from your mouth because these folks have to hear it. Okay? Now, I need you to speak into the mic. Do you know someone by the name of Anthony Williams?
Yes.
Do you know what his nickname was?
Sack.
Do you know someone by the name of Christopher Thomas?
Yes.
Do you know what his nickname was?
Juvy.
Do you know a person by the name of Cortlen Henry?
Yes.
And do you know his nickname?
Yes.
What is it? Do you know,
I'm sorry, I didn't hear you.
I'm sorry,
Bort.
Bort, B-O-R-T. Do you know Jamell?
Yes.
Do you see him in the courtroom today?
Yes.
Would you point him out for us?
Right there.
This young man right here?
Yes.
Do you know him by another name?
Melly.
Do you know someone by the name of Trevon Glass?
Yes.
Do you know his nickname?
Fetty. Thank
Do you know someone by the name of Jacoby Mills?
Yes.
And do you know his nickname?
Kobe.
And how about, do you know someone by the name of Dontavius Withers?
Yes.
And do you know his nickname?
Tate.
Let's start off with the first individual I named, Anthony Williams, also known as Sack. How did you meet him?
9th to 10th grade school.
How about Christopher Thomas? How did
Same.
you meet him?
During school.
Bortlen or Cortlen Henry?
I met him in elementary.
How about Melly?
6th grade.
Trevon Glass?
Probably during school, 9th to 10th grade.
And his nickname was
Fetty.
Jacoby Mills?
Since elementary.
Okay. And finally, Dontavius Withers.
Down here, for a lot of the.
So you went to school with Williams, Thomas, Henry, Melly, Glass, and Mills. Is that correct?
Yes, sir.
Everybody's talking. I'm moving. At any time during school, did any of you have any problems with each other?
No, not at all.
Would you label yourself Good friends, associates, close friends, or what?
Good friends, close friends, best friends.
Now, did Melly also have another name besides Melly and Jamell?
Yeah.
What was it?
We only called him that, those crazy legs.
Crazy Legs.
Yeah.
And why was he called Crazy Legs?
Because he liked to dance.
And that's why he got that nickname.
Yeah.
Was Melly a big kid, normal size kid when you guys were in school?
He's small.
Did there come a time that Melly, and when I'm referring to Melly, I'm referring to this young man, Jamell.
Yes.
Did there come a time that Melly got involved in the music industry,
Yes.
specifically rap music?
Yeah, back then.
Now, you grew up where?
Vero Beach.
And you still live up in that area?
No, sir.
Where do you live?
West Palm.
And by the way, what do you do for a living?
My granddad owns properties, rental properties and stuff, real estate. So we just cut grass, paint, whatever we need to do, keep the properties up.
I want to draw your attention to the year of 2018. Did there come a time that you came down to Broward County, Miramar, Florida?
Yes.
About when was that?
I don't remember exactly, but I want to say probably like September, July, something.
Okay. And where did you stay?
At Jamell's house.
Who else was living at Jamell's house when you came down in August or September of 2018?
Me, Jacoby, Melly, Sack, Juvy,
Juvy was Christopher Thomas.
yes, Tay, and Cortlen.
And was Melly in the rap music business at that time?
Yes, I believe so. Yeah.
Did you all get along together?
Yes.
Were there ever any arguments, fights amongst you guys?
No.
And is that where you met Dontavius Withers?
Yes.
And does he have a nickname?
Tay.
Who was paying the bills at the house?
I don't know, but I'm pretty sure Melly was.
Let's go to the day of October 25th, and so you have an idea where I am. This incident that we're here on occurred in the early morning hours of October 26th. Okay? And I'm referring to the shootings of Anthony Williams and Christopher Thomas. On October 25th, the morning of, and during the day, what were you doing?
Just chilling at the house, hanging, smoking and drinking.
Who were you smoking and drinking with?
Jacoby, Tay, everybody who usually be at the house.
Okay. Williams,
Yeah.
Thomas,
Yes.
Cortlen Henry,
Yes.
Trevon Glass,
Yes.
Dontavius Withers.
Yes.
And were there plans to go to a recording studio that evening?
Yes.
Did you in fact go to the recording studio?
Yes.
And that was after you all were, for lack of a better term, smoking dope, weed,
Yeah.
correct? And having a few drinks?
Yeah.
What was the drink of choice, out of curiosity?
Hennessy.
Hennessy.
Yeah.
Who all went to the studio?
Me, Jacoby, Melly, Juvy, Cortlen, Trayvon, and Tate.
Okay. Do you all go in the same car?
No,
Okay. Going to the studio, approximately what time did you get there?
I don't remember.
Was it during the day or at night?
At night?
Did you go in the same car, or were there two cars?
We took 2 cars.
What type of cars were they?
A Jeep and Mitsubishi.
What color was the Mitsubishi?
Red.
Will you tell this jury who got into the red Mitsubishi to go to the studio?
Me, Jacoby, Tay, and Fetty, Trayvon.
And who got into the Jeep to go to the studio?
Melly, Juvy, and Bort.
Do you know who drove the Mitsubishi to the studio?
Tay.
That would be Contagious with us.
Yeah.
Do you know who drove the Jeep to the studio?
I think Bort did.
Okay, that would be
Cortlen Henry, yeah.
And what was the purpose of going to the studio?
To make music.
Did anyone fall asleep at the studio?
Yes.
Who?
We all did.
That was from the day of smoking weed and having a few drinks.
Yeah.
Fair enough. Did any arguments occur between any of you at the studio?
Not at all.
Did there come a time that you all left the studio?
Yes.
Did you leave the studio earlier than what was scheduled?
Yeah, I believe so. So we were all in there asleep.
Will you tell the jury who got into the red Mitsubishi?
Me, Jacoby, Trayvon, and Tate, Dontravius.
You know who got into the Jeep?
Cortlen, Jamell, Sack, and Juvy.
Where were you going? Did anyone fall asleep in your car?
Yeah, we about all did except for the driver.
Did there come a time that you were woken up before you got to the house?
Yes.
What happened?
We pulled over, and that's when Melly got in the car with us.
Do you know where you pulled over?
And I don't really remember.
Were you woken up?
Yeah, but
Why?
it was like, because I was getting pushed over a little bit.
And are you 100% sure that this young man got into the red Mitsubishi?
Yes.
What happened to the Jeep?
I think they just kept going.
Where'd you go? Did he have to unlock the door?
Yes.
Do you know who has the keys to Melly's house on October 26th in the early morning hours?
Jamell and Bortlen. They the only one who had keys to the house.
Did you have a key to the house?
No.
Did Williams have a key to the house?
No.
Did Christopher Thomas have a key to the house?
No.
Did Trevon Glass have a key to the house?
No.
Did Jacoby Mills have a key to the house?
No.
And how about Dontavius Williams? Did he have a key?
No.
Okay. So the only two people you know who had a key to the house was this young man
Yes.
and Cortlen Henry.
Yes.
Did you see this young man unlock the door of the house?
Yes.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon, he was in the hospital asleep.
He was in the car asleep when you got to his house?
Yeah.
Did you see where Melly went?
To his room.
And where was his bedroom?
When you first walked in the house, can't miss it. It's right down the left.
Okay. This is a 1 or 2 story house.
2.
Where did you go? Where did Dontavius Withers go? Where? I'll break it up.
Thank you.
Do you know where Dontavius Withers went?
To his room upstairs.
Do you know where Trevon Glass went?
To the room upstairs.
Do you know where Jacoby Mills went?
He slept on me.
So the 3 of you, the 4 of you went upstairs,
Yeah.
correct? And this young man went into his bedroom.
Yes.
Same. Rephrase.
How many people went upstairs to go to sleep?
3.
And you?
Yeah.
That would be
Me, Jacoby, Melly. Well, no, Melly was downstairs in his room. Me, Jacoby, Fetty, and Tay. So 4 of us.
okay. And Melly went to his bedroom.
Yes.
Did there come a time in the early morning hours that you were woken up and heard some distressing news?
Yes.
What did you hear?
That second Juvy was shot.
When you heard that, did you see Melly in the house?
Yes.
Did you see Melly how he was dressed in the house?
Yes.
What was he wearing?
Shorts and a t-shirt, I think.
Okay. Upon hearing that Sack and Juvy, and I really should use the correct names, Anthony Williams and Christopher Thomas, were shot. What did you guys do?
We were already dressed and stuff, so we just left with Fredo's house.
Was anybody upset or crying?
Yeah, we all were crying.
Was this young man crying?
Yes.
Are you sure of that?
Positive.
And where'd you go?
Fredo's house.
That would be Fredo Bang.
Yeah.
Do you know Fredo Bang's real name? Frederick Gibbons, by any chance?
Yeah, I think I've seen it.
Did there come a time after you got to the house of Fredo Bang that Cortlen Henry showed up?
Yes.
Did Cortlen Henry tell you what happened?
Yeah, he said it was a drive-by.
Same.
When Cortlen Henry arrived at Fredo Bang's house, was Melly there?
Yes.
Did you eventually leave that house?
Yes.
Approximately what time did you leave that house?
I really don't remember.
Where'd you go?
Back to Jamell's house.
Who went with you?
Me, Trayvon, Jacoby, and Fetty.
By the way, when you first learned that Anthony Williams and Christopher Thomas were shot at the house with Melly.
Mm-hmm.
Did anyone get on the phone?
Yeah.
Did anyone have any problem locating their phone?
Yes.
Who was that?
Jamell.
You, when I backed up for a minute, you were telling the jury that you went back to Melly's house.
Mm-hmm.
You got an answer, yes or no? She
Oh, yes.
She can't take down, shaking your head. How'd you get in?
The door was unlocked.
Were you aware whether or not Melly had a contractual agreement to do a video shoot that day?
Yeah, it was something like that. I know he probably would have lost a lot of money if he didn't go to the music video. He was upset.
Was Melly crying at Frito Bank's house?
Yes.
Were you crying?
Yes.
Because you all grew up together.
Mm-hmm. Yes. Yeah.
Now, did you in fact tell this what happened on October 25th and 26th to this particular prosecutor?
Yes.
Were any of us, any of the lawyers present?
Objection, relevance.
Sustained.
Did you tell the prosecutor when you spoke to the prosecutor? Were you under oath,
Yes.
sworn to tell the truth?
Yes.
Objection, proper bolstering.
Sustained.
Are you 100% sure
Objection asked and answered.
that Melly got into the red Mitsubishi to go home?
Yes.
Are you 100% sure that this young man learned of the shooting of his friends at the exact same time you learned of it?
Yes.
And that was at the house.
Yes.
Are you 100% sure that when people were getting on the phone, that this young man was looking for his phone to call people?
Yes.
May I have one moment, please?
Yes.
I have no further questions.
Counsel, is there any cross-examination?
Yes, Your Honor.
You're ready to make proceed?
Thank you. Mr. Davis, you said you're 100% sure that Mr. Demons found out at the same time you did.
Yes.
No questions about that. You're sure he was at that house?
Yes.
And you were upstairs?
Yes, ma'am.
He was downstairs.
Yes.
But you're sure he was there. You could see him.
Mm-hmm.
Is that a yes?
Yes.
And you are 100% sure his phone was missing?
Yes.
Where in this statement on May 5th did you ever say that?
Objection.
This objection.
It was never asked.
Thank you. Counsel, so I guess the objection is improper impeachment, so rephrase your question. I sustain the
So,
objection.
you met with me on May 5th, 2022, you remember that?
Yes.
And you remember sitting down, you were present? That's a yes?
Yes.
Your two attorneys were present that you brought? That's a yes?
Yes.
And I asked you questions for quite a number of hours. Do you remember that?
Yes.
Okay. And do you remember being asked if you had met with anyone else with regards to this case?
Yes.
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
Yes.
Okay.
I didn't know who they were, and my lawyers told you that.
Okay.
I didn't know their names.
But you remember meeting with them?
Yeah.
Okay. And do you remember asking and being asked a question about what you talked about with them?
Yes.
Did you remember what you told them?
No.
Do you remember what you told them now?
Yes.
So are you telling this jury that when you were speaking with me, you forgot?
As in, what I'm telling them now, as of right now, yes.
So on the phone on that, do you remember if Mr. Demons had a passcode on his cell phone back then?
I don't think so.
You don't think so? And in terms of, would you be surprised to find that there was one on that cell phone?
No.
Did you know the passcode?
I don't think so. I don't even remember if he had one. We all use this phone sometimes. We all use each other's phones.
So you would use his cell phone? Why?
Talk to females.
You'd pretend to be him to get women? Because you couldn't get them on your own?
Objection.
Why would you use his phone then?
Let me rule before you ask the next question, all right? It's overruled. Go ahead, answer your question. Go ahead, ask the next question.
So, with regards to your living situation there, you were not paying any rent, right?
Oh, no.
And nobody was paying any rent in that house except for the defendant.
Yeah, I'm pretty sure.
So, do you remember that evening driving to the studio?
Yes.
You remember who was in which car?
On the way there, yes.
And you remember who was on each car on the way back?
Yes.
Okay. Were there any threats that were made to anyone that night?
No, ma'am.
Did anyone have any other conversations or discussions about threats from outside parties?
No, ma'am.
Was anyone worried about their safety?
No, ma'am. But Melly's a rapper, you know, he's always going to be a target.
I'm sorry.
I said he's a rapper, so he's always going to be a target.
Okay. And do you remember stopping on the side of the road?
Yes.
Where did you stop?
I don't remember. It's like flashes and blinks, drinking and smoking, so I just know we stopped.
You know you stopped.
Yeah.
Okay. And do you remember if that was on a highway?
Not at all.
Okay. Do you remember if it was on a divided 4-lane road?
No, ma'am.
Do you remember if you guys were using GPS to get home?
No, ma'am.
Okay. Do you remember if you knew the route home?
No.
Okay. Do you remember what phone number you had back then?
No, ma'am.
You don't remember your phone number?
5 years ago, so.
Okay. Do you remember if you were awake or asleep?
Just told you. We were asleep.
You were asleep.
Yeah.
And you said you were intoxicated?
You did answer out loud.
Yes.
Do you know why the car stopped?
No.
Do you have any conversations or messages with the defendant?
No, ma'am.
Did you have a phone call with him?
No, ma'am.
When you stopped, was the gray Jeep in front of the red Mitsubishi?
Yeah, I believe so.
Have you ever answered that question differently?
I don't think so.
If I were to show you your statement from May 5th of 2022, would that help you in answering if you'd ever said something different than what you just testified in court?
Yeah, probably.
Okay, approaching with page 33 of the statement, counsel. Will you just read silently to yourself?
One line?
Lines 18 through 20.
Yeah. I basically told you I don't remember.
Okay, so now your answer is I don't remember if the Jeep was in front or the Mitsubishi was in front.
If you watched the video, they pulled off first, so I knew it was in front of us.
Oh, so you watched the video.
You showed it to me.
In terms of the trial, have you been watching that online?
No, ma'am.
Okay. In terms of when you got home, you mentioned that you said Mr. Demons went to his room.
Yes.
Have you ever answered that question differently?
No.
Okay. On May 5th, 2022, remember that statement?
Mm-hmm.
At that point, did you say, I don't know where he went? I assume his room.
I don't know.
You don't know. But looking at your statement, help refresh your recollection on that?
Yes.
Okay, page 34, lines 12 and 13, counsel.
Yeah.
Okay, so did you previously give a different statement that you didn't know where he went and you were assuming he went to his room?
Yeah. He went into the room.
So with regards to the car, you're saying that you got pushed over when somebody got in the car?
Yeah.
Okay. And with regards to being pushed over, did you wake up when that happened?
Like it was flashes. Like yeah, I guess you could say I woke up.
Okay. And did they move you over or climb over you?
I don't remember.
Have you ever made a statement different than that?
I don't know. I can't remember.
Okay. Again, page 33. Question was asked: did they climb over to get you to the middle, over you to get to the middle of the back seat? Your answer was, I think I was at the window, so no. I think they might have climbed over.
Okay.
So, is it your testimony that somebody climbed over you, or you pushed over,
I mean,
or that you don't remember?
yeah, I don't really remember.
You don't really remember.
Yeah.
Okay. And in terms of the phone, right? Did you see anyone get into that gray Jeep?
No.
You remember going to Frito Bank's house?
Yes.
Okay. And you remember seeing the defendant there? Is that a yes?
Yeah, he was there with us.
And you remember leaving there afterwards?
Yes.
And you remember going back to the defendant's house?
Yes.
Okay. And you remember at that point that when you went back to the defendant's house, it was you, Travion Glass, or Fetty, and Jacoby Moss. That's it?
Yes, I believe so.
Okay. And you said that you were in and out of sleep and intoxicated.
Yes.
And in terms of you remember that Travion was the last person to get out of the car?
Yeah, I believe so, yes.
You believe so, or do you remember? Which is it?
Yes.
And you know, and you mentioned about Mr. Demons looking for his phone, right?
Yes.
So of course he used your phone to call it and try and find it, right?
I don't remember.
You don't remember how he was trying to find his phone?
Just in the house looking for it, just like you would do if you lost yours.
So he didn't, try and do Find My iPhone or anything like that. Of course he used yours to do that, right?
I don't remember.
Of course he used something like, an Apple iWatch and set it up.
Objection, there's no testimony that he had
I
it.
don't remember.
Excuse me.
Okay.
One at a time. You asked the question. Objection noted. Overruled.
So of course he did all that. He went on Find My iPhone and he's looking for it.
I don't know. I don't remember.
You don't remember. Okay. And of course he is using everybody else's phone to try and find it.
I don't know.
You don't remember. Okay. But conveniently the phone's missing that morning.
Objection to the form.
Sustained.
Yes.
I sustain the objection.
So with regards to your conversation, you had texted back and forth with the defendant prior to this event occurring, right?
Yes.
And he had sent you a picture of his driver's license from that phone number.
Yes.
Oh. So you knew Mr. Demons, the defendant Melly, to use that cell phone 772-713-9807.
I don't know what the numbers is.
You had it saved in your phone, right?
Yeah, but I can't just remember a phone number like that from that long ago.
Oh. And your testimony is that he's looking all over the house.
Yeah.
So in terms of the phone, did you see it again that day?
I don't remember.
Don't remember. Okay. And in terms of the phone traveling up to the video shoot up in Cocoa, you don't know how the phone would have gotten up there.
I don't know.
And you didn't shoot Mr. Williams or Mr. Thomas, right?
No.
But you know who we're talking about, right?
Chris and Anthony.
Yes. And in terms of the messages and things for Mr. Henry, you're aware that his phone was broken at that time, right?
I don't know.
You don't know.
I don't know.
In terms of Mr. Demons, you know he was dating Mariah Hamilton.
Yeah.
Okay. And you know that Mr. Demons would FaceTime her on a regular basis.
Objection.
What's the objection?
There's no evidence of that.
I don't know.
Overruled.
So you know, and Mr. Demons would,
Excuse me, use the correct name.
Mr. Demons, my apologies. Mr. Demons would FaceTime and video chat frequently.
Yes, that's what you got a phone for.
And Mr. Davis, you never met with Detective Mark Money? You never gave a statement?
No, ma'am.
And so the first time that you ever said anything about the phone being missing was today, July 18, 2023?
Yes, I believe so.
Okay. Nothing further, Your Honor.
Few questions.
Is there any regret? Go ahead, sir.
Detective Moretti never even talked to you during this investigation, did he?
No, sir.
And the bottom line is, at the time you learned that Christopher and Anthony were shot, Sack and Juvy were shot, this man was at his house, correct?
Yes, sir.
And did you tell that to the state?
Yes.
And were they the first ones who contacted you about this case?
Yes.
Thank you.
Is this witness excused?
Yes.
Sir, thank you very much. You may step down. You're excused. Counsel?
We would, at this time, yes.
Ladies and gentlemen, I need a few minutes with the attorneys. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research. All right? Just leave your notepads on your chairs. Thank you. Thank you. Let the record reflect the jury stepped out, counsel remained, along with the defendant. And I guess Mr. Demons, I need to talk to you, ask you a few questions. All right? You heard what your attorney said. He said he's rested. No further witnesses. Do you hear that?
Yes, sir.
All right, now, I don't know what discussion you had with your attorneys. You've got competent lawyers there. I mean, you've seen them perform here. You've discussed things with them, I assume, correct?
Yes, sir.
And you understand that you have a right to testify, and you also have a right not to testify. Do you understand that?
Yes, sir.
You understand that if you do testify, I'm going to instruct the jury that they have to consider your testimony as they would any other witness. Do you understand that?
Yes, sir.
And if you don't testify, I'm going to instruct the jury that you have a right not to testify, and they can consider that, hold that against you. Do you understand that?
Yes, sir.
So my question, I guess, is did you have enough time to talk about this issue about you testifying or not testifying? Did you have enough time to discuss that with your attorneys?
Yes, sir.
Did they answer all your questions?
Yes, sir.
And what is your decision?
I will not testify.
You will not be testifying.
No, sir.
Is anyone forcing you or coercing you to make this decision?
No, sir.
Anybody make any promises or on the contrary, make any threats to get you not to testify?
No, sir.
This is your free and voluntary decision.
Yes, sir.
So let me go further. You heard your attorney said he rests, he's not going to call any other witness. That includes you, but no other witnesses. You understand that?
Yes, sir.
Is there any other witnesses that you wanted your attorneys to call and present to the jury?
No, sir.
Any other evidence that you wanted your attorneys to present to this jury?
No, sir.
You good? You satisfied with their performance?
Yes, sir.
All right. And everything that you wanted the jury to hear and listen to is before the jury. Is that right?
Yes, sir.
Thank you, sir. Let me ask, State, are you going to call any other witnesses?
No, Your Honor.
So the State's going to rest as well?
Yes, Your Honor.
What happened with Mr. Brendan Collins? He's not going to be used, I guess?
No,
The
sir.
defense emailed me last night saying that they were not going to be calling him and he could be excused. I forwarded that email to Mr. Collins.
Thank you. So both sides have rested.
That's correct.
And now the pleasure is we can talk about the jury instructions, but what about the closing argument? We're going to do that on Thursday.
Yes, Your Honor.
So I'll tell the jury that come back Thursday. That's what the parties agreed to, and tell them to pack a bag. And Tom and Gary, you're going to talk to the jury about that, to tell them what they need and what they can anticipate.
Yes, sir.
Right? And about the cars, where they park the cars. And things.
Yes, sir.
There's a whole host of things he has to go over with the jury when they come back on Thursday about food and things like if there's special dietary things that they have to have and things such. They have a list they go over with. All right. So yes, sir, you had
Yeah,
hand
as-
raised. Something to
as-
discuss?
Yeah, as a legal matter, Your Honor, we'd like to, at the close of the defense case, renew our motion for judgment of acquittal, and renew all other motions and objections made. But our argument is the same with respect to the judgment of acquittal, that no reasonable jury could find proof beyond a reasonable doubt based upon the evidence that was presented, and that it invites to give this case to the jury would invite a verdict based upon speculation.
Thank you. They wish we heard.
Your Honor, at this time, the state would submit that reasonable minds could differ. There is plenty of evidence and mountain in front of Your Honor upon which the jury could find, and a jury should find, the defendant guilty of first-degree murder as to both defendants. If Your Honor wants additional information as to each element on that, but the state would submit that the case speaks for itself.
Thank you. As I said, I'll defer ruling on it. So I'm going to bring the jury in and send them home. All right?
Yes, sir.
Let's go. Bring the jury in, please. Judge. Now we're in recess for a minute.
Thank you.
We'll mark it. Leave it with the court.
Thank you. So, you have your witness here?
We do, the court ruled on the judgment of acquittal.
Defer ruling.
It's
I'm not ruling on it.
Okay.
All right? I'll bring the jury in.
You want me to go get a witness?
That'd be great. Thank you.
Wow. So the judge, Bob Hiller, denied the whole tape coming in where the state argued 2 minutes of it proved that the ending was a sort of a confession when they said there was a drive-by shooting indicating that Melly had to be in the car. Right ruling or wrong ruling, Bob Hiller?
I have a feeling the judge just gave the defense on appeal a gift. You know, there was in the state's case a segment of this filming that was used really to advance the state's theory that this killing was motivated by some sort of gang relationship, and that what they excerpted from this suggested that and showed a gang affiliation. And, you know, again, I think the defense made all the correct arguments, and the judge's obligation is to make sure that the jury gets the evidence accurately and fairly. And if the state is introducing, and remember the state introduced it, and the argument that, well, we can't cross-examine, well, you can cross-examine some of the people in the video. You can cross-examine the people who were the producers of that video. You can't cross-examine the defendant, certainly if the defendant doesn't take the stand. But, you know, again, so I'm perplexed at why the court felt that somehow this was injecting an issue into the case that wasn't in the case, or that it was somehow going to mislead the jury unfairly from what the state already tried to show with a portion of this.
Yeah, probably the judge thought that agree with the prosecution that Melly could show himself in a very, Jamell Demons, that is, in a very good light without having to take the stand. And Bob Hiller says that is a major appealable error should Mr. Demons get convicted. Anyhow, we're going to take a quick break. On the other side, more of the YNW Melly case, defenses in their case. Stay with us.
Judge, I object to that, because then the jury goes out just hearing their side of the story. I strongly oppose letting them sleep overnight on what they have said without
Not on the record.
no, without an equal opportunity. So I would ask Your Honor to basically.
Well, then let me ask you this. So what happens if we're here, and counsel's taking her 4 hours, and you think, based on what she says, you need more time, and we're here, and at 5 o'clock comes, we're not done with this, and they're coming to take the jury to sequester the
Well, that's why I would ask you to consider certainly limiting the time to 3 hours. Judge, for the record, I'm used to doing closing arguments in federal court where I'm lucky, and David Howard would verify, and even in state court, in months-long trials of getting, if I'm lucky, 30 to 40 minutes, quite candidly. So certainly 3 hours is more than adequate to solve this issue. So I would ask the court to go and say, do it in 3.
jury rating.
Okay.
You brief your let's back on the record.
Jury entering.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendants, his counsel, the assistant state attorneys, and the ladies and gentlemen of the jury. As you've heard, ladies and gentlemen, the state is, the defense has rested their case. The state has no additional evidence or witnesses. Is that correct?
Yes, Your Honor.
And the state is also rested. There's no further evidence in the case. So what I need to do is get the jury instructions done. I need some time to do that with the attorneys, and then they're going to present their closing arguments. There's an issue we had here that I can't be in session on this case tomorrow morning, so my thought is we're going to do closings all in one day on Thursday, all right? So don't discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, and certainly no research. Now, when you come back on Thursday, Gary's going to discuss with you the sequestration. He'll talk about different things with you, what you need to pack and everything else, because typically on that first night, we're going to you'll be in a hotel, all right? And that's the whole idea of sequestration we talked about a little bit before dire. So Gary's going to talk to you about it. He's going to explain where to park, what issues may come up, things like that, how to get in contact with us and things like that. If you have family members or friends want to get a hold of you, he'll explain all that, how that works. All right, so when you come back Thursday, you're going to bring a bag with you, all right? So and Gary will give you more explanation on that as well. All right. So just remember the admonition we gave you not to discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. No research, and we'll see you back here Thursday. All right. Thank you, ladies and gentlemen. 9 a.m. Thursday. Good morning again. Let the record reflect the jury stepped out, counsel remained along with the defendant. Anybody need a restroom break?
Yes, please, Your Honor.
All right, so I'll always see everybody back in about 10 minutes and we'll start with the jury instructions.
Yes, sir. Mayor, I gave counsel and Your Honor a memorandum of law and case law on the felony murder issue. I know we talked about it briefly quite a number of months ago.
I don't remember, but I have your memorandum here. I assume you have it, counsel?
Yes.
All right, thank you. We're recessed.
with some of that information because he had been interviewed after the fact by her, and he did not say those exact same things. He couldn't remember whether or not Melly was in his room or where exactly he was. But at the end of the cross-examination, there was a very short redirect, very short recross, and ultimately the state and the defense, they both rested. You told me chronologically, so they rested. Then after that, we did hear the defense renew all of the motions making sure that all of those motions have been renewed, making sure that they are protecting that record for appeal. So bombshell this morning. It was a big morning for the defense. And frankly, you know, I'm looking at this from the perspective of what evidence went into this case, not whether somebody's guilty, not whether somebody's innocent. The evidence this morning basically really supported the defense's argument that YNW Melly did not commit this crime.
Oh my gosh, Terry, so much to digest right there. Let me ask you, did the prosecution know in advance that this is the statement of Adrian Davis, that he had told people, told them that indeed Melly had left the Jeep, the gray Jeep, and gotten into the red Mitsubishi before the shooting?
Linda, that is an excellent question, and the answer is yes, the prosecution knew, because that question was asked by the defense. Did you tell the prosecutor, did you tell Ms. Bradley that Melly got out of the car and came into the red Mitsubishi? And the answer to that was yes. There was another piece of information that I thought was interesting as well. The defense confirmed that Mark Moretti did not investigate, did not interview, did not talk to Adrian Davis. And even though Adrian Davis said to the prosecutor, listen, this is what occurred, that was not followed up. So again, I think it was another point. Again, I'm just looking at the evidence, I'm looking at what's coming in, and based on what came in this morning, that was a point for the defense.
And indeed, the prosecution and defense wrangled over an issue of alleged confession yesterday with the word, I did that, shh. And it turns out that Adrian Davis said that Melly was looking for his phone. So that would also help the defense, wouldn't it?
Yeah, I mean, that statement, I did that, shh, that was read into evidence yesterday by Mark Moretti, and I do think that that was a point for the prosecution. But if you recall, Gambino was talking to him. He asked him, was he okay? Melly responded, theoretically, I did that. It was out of context. Frankly, I'm not sure what that jury is thinking. I don't know what to think about that. I'm not sure that's a response to a question, are you okay? So I don't know what the jury is going to make of that. Obviously, that's evidence, in my opinion, that helps the prosecution, and perhaps the jury will look at that as though it's some sort of admission. But it was a message that was a bit out of context as far as I'm concerned. That did not come back up today. Today, the first thing they talked about this morning, if you recall, was whether or not that documentary would come into evidence. The judge listened to the entire documentary. The only portions that the prosecution introduced were the beginning and the end. The beginning basically just showed Melly sort of playing around in the car, driving, saying, look, everybody follows me, everybody listens to me because I'm good, I've studied my trade, you know, and I know what I'm doing here as far as being a rapper. And then the very end, the prosecution also earlier admitted that into evidence, where there was the message at the end that said that all of them were targets of a shooting, and that obviously Juvy and Sack didn't survive. So they wanted to put the whole video in today. That's what the defense started out with this morning. The judge listened. The judge said, no, I think it's not relevant. It's self-serving. Those are the things that the prosecution argued, and the prosecution won that argument.
Yeah, but they didn't win the argument of Adrian Davis coming in and saying, I told the prosecutor that indeed Melly had left the car, and no one, including the lead detective, had interviewed me. Terry, very interesting morning. I'm going to let you go. We're going to digest this here. But wow, defense has rested with some bombshell testimony. Thank you so very much.
Thank you, Linda.
And right now, we're going to take a quick break. When we come back, Bob Hille is here. He is the former president of the New Jersey State Bar Association, written a lot of articles about trial advocacy. He's going to break this down for us on the other side. YNW Melly, bombshell testimony. Stay with us.
Yes, sir.
Please state your full legal name for the record.
Adrian Shaw Davis.
Please spell your first and last name for the court.
ADRIANDAVIS.
Thank you, sir.
Please have a seat. Davis, that microphone in front of you will adjust up or down, but does not move back and forth. Okay, you ready to go?
Yeah.
Counsel, you may proceed.
Good morning. How old are you?
24.
Have you ever been convicted of a crime?
Objection,
No.
Your Honor, improper bolster.
Thank you. I need to know an answer. Come side order.
Nickname?
Yes.
What is it?
AD.
Okay. First of all, take your hand away from your mouth because these folks have to hear it. Okay? Now I need you to speak into the mic. Do you know someone by the name of Anthony Williams?
Yes.
Do you know what his nickname was?
Sack.
Do you know someone by the name of Christopher Thomas?
Yes.
Do you know what his nickname is?
Juvy.
Do you know a person by the name of Cortlen Henry?
Yes.
And do you know his nickname?
Yes.
What is it? Do you know,
I'm sorry, I didn't hear
I'm sorry,
Board.
Bort, B-O-R-T. Do you know Jamell?
Yes.
Do you see him in the courtroom today?
Yes.
Would you point him out for us?
Right there.
This young man right here?
Yes.
Do you know him by another name?
Melly.
Do you know someone by the name of Trevon Glass?
Yes.
Do you know his nickname?
Fetty. Thank
Do you know someone by the name of Jacoby Mills?
Yes.
And do you know his nickname?
Kobe.
And how about, do you know someone by the name of Dontavius Withers?
Yes.
And do you know his nickname?
Tay.
Let's start off with the first individual I named, Anthony Williams, also known as Sack. How did you meet him?
9th, 10th grade school.
How about Christopher Thomas? How did you meet him?
During school.
Bortlen or Cortlen Henry?
Met him in elementary.
How about Melly?
6th grade.
Trevon Glass.
Probably during school, 9th to 10th grade.
And his nickname was
Fetty.
Jacoby Mills.
Since elementary.
Okay. And finally, Dontavius Withers.
Down here. Fort Lauderdale.
Okay. So you went to school with Williams, Thomas, Henry, Melly, Glass.
Bob Hiller, let me talk to you about this. Not only do we have testimony now, which is what the defense said, that YNW Melly was not in the Jeep at the time of the shooting, but that the prosecutor knew, never mentioned it to the jury. The lead detective never interviewed one of the people that was in the car, the red Mitsubishi. I am dumbfounded. Your thoughts?
Well, I think that's going to be a real important thing for the jury to consider here, because, you know, if they believe this witness, and a jury can always reject, you know, any witness's testimony as not believable or credible, but if they believe him, certainly he has some relevant information. There was no question he was there. He places the defendant elsewhere, and he says he told the police. You didn't hear that the police denied it, he told them, but there was no follow-up. So I think that the gaps here between the surveillance and the murder, that's going to have a question in the minds of the jury.
And indeed, the defense had argued that YNW Melly, Jamell Demons, was targeted because of who he was. The investigation was not fair. And now we know why they don't call an accident reconstructionist, because they're going to say that YNW Melly, have said, was not in the car. Anyhow, so much to digest. We're going to take a quick break here at Law&Crime. Please join us on the other side. Stay with us. I'm so glad you're back to join us here with our live analysis on Law and Crime, because so much is happening in that courtroom. As you know, I'm Linda Kenny Bodden. Both sides rested today in the YNW Melly double murder trial in Broward County, Florida. Closing arguments are slated for Thursday. The 24-year-old Jamell Demons faces the death penalty in the 2018 shooting deaths of his two friends, Anthony Williams and Christopher Thomas Jr. Demons and his co-defendant, Cortlen Henry, claim they were the victim of a drive-by shooting, but the evidence suggested by the prosecution, or in the prosecution, says that the shots were fired from inside the vehicle in a position where Melly was sitting. But now we're listening to the one and only defense witness who levied some bombshells in that courtroom this morning on behalf of the innocence claim of YNW Melly. Let's listen to Adrian Davis.
Is that correct?
Yes, sir.
Everybody's talking. At any time during school, did any of you have any problems with each other?
No, not at all.
Would you label yourself good friends, associates, close friends, or what?
Good friends, close friends, best friends.
Now, did Melly also have another name besides Melly and Jamell?
Yeah.
What was it?
We only called him that. Those Crazy Legs.
Crazy Legs.
Yeah.
And why was he called Crazy Legs?
Because he liked to dance.
And that's why he got that nickname.
Yeah.
Was Melly a big kid, normal sized kid when you guys were in school?
Small.
Did there come a time that Melly, and when I'm referring to Melly, I'm referring to this young man, Jamell.
Yes.
Did there come a time that Melly got involved in the music industry?
Yes.
Specifically rap music?
Yeah, back then.
Now, you grew up where?
Vero Beach.
And you still live up in that area?
No, sir.
Where do you live?
West Palm.
And by the way, what do you do for a living?
My granddad owns properties, rental properties and stuff, real estate. So we just cut grass, paint, whatever we need to do, keep the properties up.
I want to draw your attention to the year of 2018. Did there come a time that you came down to Broward County, Miramar, Florida?
Yes.
About when was that?
I don't remember exactly, but I want to say probably like September, July, something.
Okay. And where did you stay?
At Jamell's house.
Who else was living at Jamell's house when you came down in August or September of 2018?
Me, Jacoby, Melly, Sack, Juvy,
Juvy was Christopher Thomas.
yes, Tay, and Cortlen.
And was Melly in the rap music business at that time?
Yes, I believe so. Yeah.
Did you all get along together?
Yes.
Were there ever any arguments, fights amongst you guys?
No.
And is that where you met Dontavius Withers?
Yes.
And does he have a nickname?
Tay.
Who was paying the bills at the house?
I don't know, but I'm pretty sure Melly was.
Let's go to the day of October 25th, and so you have an idea where I am. this incident that we're here on occurred in the early morning hours of October 26th. Okay? And I'm referring to the shootings of Anthony Williams and Christopher Thomas. On October 25th, the morning of, and during the day, what were you doing?
Just chilling at the house, hanging, smoking and drinking.
Who were you smoking and drinking with?
Jacoby, Tay, everybody who usually be at the house.
Okay. Williams?
Yeah.
Thomas?
Yes.
Cortlen Henry?
Yes.
Trevon Glass?
Yes.
Dontavius Withers?
Yes.
And were there plans to go to a recording studio that evening?
Yes.
Did you in fact go to the recording studio?
Yes.
And that was after you all were, for lack of a better term, smoking dope, weed,
Yeah.
correct? And having a few drinks?
Yeah.
What was the drink of choice, out of curiosity?
Hennessy.
Hennessy.
Yeah.
Who all went to the studio?
Me, Jacoby, Melly, Sack, Juvy, Cortlen, Trayvon, and Tay.
Okay. Do you all go in the same car?
No.
Okay. Going to the studio, approximately what time did you get there?
I don't remember.
Was it during the day or at night?
At night.
Did you go in the same car, or were there two cars?
We took 2 cars.
What type of cars were they?
A Jeep and a Mitsubishi.
What color was the Mitsubishi?
Red.
Will you tell this jury who got into the red Mitsubishi to go to the studio?
Me, Jacoby, Tay, and Fetty, Trayvon.
Okay. And who got into the Jeep to go to the studio?
Melly, Sack, Juvy, and Bort.
Who drove? Do you know who drove the Mitsubishi to the studio?
Tay.
That would be Dontavius Withers.
Yeah.
Do you know who drove the Jeep to the studio?
I think Bort did.
Okay, that would be
Cortlen, yeah.
And what was the purpose of going to the studio?
To make music.
Did anyone fall asleep at the studio?
Yes.
Who?
We all did.
That was from the day of smoking weed and having a few drinks.
Yeah.
Fair enough. Did any arguments occur between any of you at the studio?
Not at all.
Did there come a time that you all left the studio?
Yes.
Did you leave the studio earlier than what was scheduled?
Yeah, I believe so. So we were all in there asleep.
Will you tell the jury who got into the red Mitsubishi?
Me, Jacoby, Trayvon, and Tay, Dontavius.
Okay. You know who got into the Jeep?
Cortlen, Jamell, Sack, and Juvy.
Where were you going? Did anyone fall asleep in your car?
Yeah, we about all did except for the driver.
Did there come a time that you were woken up before you got to the house?
Yes.
What happened?
We pulled over, and that's when Melly got in the car with us.
Do you know where you pulled over?
And I don't really remember.
Were you woken up?
Yeah, but
Why?
it was like because I was getting pushed over a little bit.
Okay. And are you 100% sure that this young man got into the red Mitsubishi?
Yes.
What happened to the Jeep?
I think they just kept going.
Where did he go? Did he have to unlock the door?
Yes.
Do you know who has the keys to Melly's house on October 26th in the early morning hours?
Jamell and Bortlen. They the only one who had keys to the house.
Okay. Did you have a key to the house?
No.
Did Williams have a key to the house?
No.
Did Christopher Thomas have a key to the house?
No.
Did Trevon Glass have a key to the house?
No.
Did Jacoby Mills have a key to the house?
No.
And how about Dontavius Williams? Did he have a key?
No.
Okay. So the only two people you know who had a key to the house was this young man
Yes.
and Cortlen Henry.
Yes.
Did you see this young man unlock the door of the house?
Yes.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon, he was in the cockpit asleep.
He was in the car asleep when you got to his house?
Yeah.
Did you see where Melly went?
To his room.
And where was his bedroom?
When you first walked in the house, it came missing. It's right down the left.
Okay. This is a 1 or 2 story house.
2.
Where did you go? Where did Dontavius Withers go? I'll bring it up.
Thank you.
Do you know where Dontavius Withers went?
To his room upstairs.
Do you know where Trevon Glass went?
To the room upstairs.
Do you know where Jacoby Mills went?
He slept on me.
So the 3 of you, the 4 of you went upstairs, correct? And this young man went into his bedroom.
We're coming out, and we're going to take you back in, but I wanted to introduce our guest because there's some very important points here. Bridget Williams, criminal defense attorney, has joined Bob Hill with me to discuss this case. Bridget, welcome back. Bridget, let me just tell you, as a former prosecutor, as a criminal defense attorney, I shouldn't be, but I am astounded that the lead detective never interviewed everybody who was in the red Mitsubishi. They also can be considered possible victims. Certainly they have information. What are your thoughts about how this will affect the jury when Adrian Davis says that the person on trial, the young man, as the defense says, left the Jeep and entered the Mitsubishi with Adrian Davis?
Yes, all of that, Linda. Well, I'll start by saying that the defense is making such a strong statement here about only having one witness, and that one witness is saying all of the direct things that we need to hear about Melly. It's not as convoluted. It's not as convoluted as the prosecution may want you to think. That's what they're saying here. And even with all of that, when this young man, Mr. Davis, is saying, well, Melly was in the car, the red Mitsubishi with us, he got out of the Jeep, and I tried to, tell the state about this, and they didn't even have the main detective to even come in and talk to me to further this investigation. It makes it look like the state is doing a sloppy job, and they rushed to judgment in this particular case. And it even goes back to the defense's theory that they tunnel visioned into Melly without doing all of their research.
Yeah, and Bob Hill, talk about targeting. You want to say the car was targeted, and sure, somebody could target a car that Melly would have been. They thought Melly would have been in. Doesn't mean that's admission. But targeting, the defense can now argue that Melly was targeted by the prosecution, can't they, with this witness? And I've been a big one. Let me just say the defense should put on a case, but they don't really need to put on a case after this witness. They don't need to put on any more of a case.
Well, and this is really a key alibi witness. And this is all about credibility. So if the jury believes this witness, Melly wasn't there when the crime happened. And game over. So, you know, it's a great way for the defense case to sort of end this trial. But again, the key here is credibility. And his demeanor looked pretty good. I mean, the jury is going to be very careful in their assessment on this witness. They're going to watch to see whether it looks rehearsed, made up, whether it's inconsistent or whatever, and then they're going to want to see how cross goes with this witness. But assuming that he handles himself well on cross, and the jury finds that this testimony is credible, I don't know how the state is going to get around that in the jury deliberations, at least on beyond a reasonable doubt standard.
Yeah, and quite frankly, I don't know how the prosecutor is going to ever be effective in any cross when the prosecutor knew what he was going to say because she interviewed him and never told the jury about it. And that talk about credibility, prosecutors and defense attorneys have credibility issues in cases also. Anyhow, we're going to take a quick break. When we come back, we'll go right back into that courtroom to continue to hear the testimony, the bombshell testimony of Adrian Davis, which tends to exonerate YNW Melly. The defense in the YNW Melly case started their case this morning with one witness, a very concise defense, but a very important witness. His name is Adrian Davis. Who is he? He was one of the occupants in the red Mitsubishi the night the shooting happened that YNW is being charged with a double homicide of. We're going to go into court and listen because he is on direct examination still with his testimony, and then we'll undergo cross-examination. Let's see what he had to tell this jury.
Yes.
Same. Rephrase.
How many people went upstairs to go to sleep?
3.
And you?
Yeah.
That would be
Me, Jacoby, Melly. Well, no, Melly was downstairs in his room. Me, Jacoby, Fetty, and Tay. So 4 of us.
okay. And Melly went to his bedroom?
Yes.
Did there come a time in the early morning hours that you were woken up and heard some distressing news?
Yes.
What did you hear?
That a second Juvy was shot.
When you heard that, did you see Melly in the house?
Yes.
Did you see Melly how he was dressed in the house?
Yes.
What was he wearing?
Shorts and a t-shirt, I think.
Okay. Upon hearing that Sack and Juvy, and I really should use the correct names, Anthony Williams and Christopher Thomas, were shot, what did you guys do?
We were already dressed and stuff, so we just left with Fredo's house.
Was anybody upset or crying?
Yeah, we all were crying.
Was this young man crying?
Yes.
Are you sure of that?
Positive.
And where'd you go?
Fredo's house.
That would be Fredo Bang?
Yeah.
Do you know Fredo Bang's real name? Frederick Gibbons, by any chance?
Yeah, I think I've seen it.
Did there come a time after you got to the house of Fredo Bang that Cortlen Henry showed up?
Yes.
Did Cortlen Henry tell you what happened?
Yeah, he said it was a drive-by.
When Cortlen Henry arrived at Fredo Bang's house, was Melly there?
Yes.
Did you eventually leave that house?
Yes.
Approximately what time did you leave that house?
I really don't remember.
Where did you go?
Back to Jamell's house.
Who went with you?
Me, Trayvon, Jacoby, and Fetty.
By the way, when you first learned that Anthony Williams and Christopher Thomas were shot at the house with Melly, did anyone get on the phone?
Yeah.
Did anyone have any problem locating their phone?
Yes.
Who was that?
Jamell.
You, when I backed up for a minute, you were telling the jury that you went back to Melly's house.
Mm-hmm.
You got an answer, yes or no? She
yes.
She can't take down, shaking your head. How'd you get in?
The door was unlocked.
Were you aware whether or not Melly had a contractual agreement to do a video shoot that day?
Yeah, it was something like that. I know he probably would have lost a lot of money if he didn't go to the music video. He was upset.
Was Melly crying at Frito Bank's house?
Yes.
Were you crying?
Yes.
Because you all grew up together.
Mm-hmm. Yes.
Yeah. Now, did you in fact tell this what happened on October 25th and 26th to this particular prosecutor?
Yes.
Were any of us, any of the lawyers present?
Objection, relevance.
The same.
Did you tell the prosecutor when you spoke to the prosecutor? Were you under oath?
Yes.
Sworn to tell the truth?
Yes.
Objection, proper bolstering.
Sustained.
Are you 100% sure
Objection, asked and answered.
that Melly got into the red Mitsubishi to go home?
Yes.
Are you 100% sure that this young man learned of the shooting of his friends at the exact same time you learned of it?
Yes.
And that was at the house?
Yes.
Are you 100% sure that when people were getting on the phone,
So, Bob Hill, a good cross-examination is usually when you testify, but here this is their witness. This is the defense witness. It seems to me that the defense attorney is doing a lot of testifying for Anthony Davis.
Well, he's certainly getting away with a lot.
Adrian Davis, sorry.
And I think, what he's trying to do, too, is steal some of the thunder away from what he anticipates is going to be the state's attack on cross-examination. So he's trying to lay that groundwork there. But yeah, he's basically asking some pretty pointed questions. But the judge is giving him leeway on this. It is a murder trial. It's an important
death penalty
witness.
case, as a matter of fact.
Yes.
So Bridget Williams, again, he's trying to make the point that indeed the lead detective never interviewed him, one of the people in the car. The prosecutor knew and never told the jury. How does the jury view this type of testimony then? Do they feel deceived?
I'm going to say that this witness is the smoking gun for Melly's not guilty verdict if he's going to get one. The state had weeks and weeks and weeks of testimony where they didn't even bring up any type of direct information that led directly to Melly being guilty of these double murders. They just brought up information that was circumstantial. This young man speaks directly to what happened on the night of. He even gives specific facts of what they were doing, what Melly was wearing, where he went in the house, and what they did when they got home. And so if I were a juror, I would be looking at the fact that he is a witness who is speaking directly to the night in question. He is speaking directly to what happened and to what happened from his memory. He's the only witness who was present at the night in question. And so I would hold weight to his testimony. He comes across very credible to me.
Yeah, very, very interesting testimony, and now we know what the defense had up their sleeve and why they don't need to call 150 witnesses to present a case on forensics, because they have an eyewitness they feel is credible. Anyhow, we're going to take a break, but before we do that, we have an interesting report, an interesting package by our own Sierra Gillespie on a case you won't want to miss. Stay with us and listen. knew you had to come back to watch this. As you know, I'm Linda Kenny Bodden, and we are covering the YNW Melly trial, and we are hot in the middle of a direct examination on a case presented by the defense for YNW Melly. They're calling their one and only witness. His name is Adrian Davis, and why is he important? He was in the red Mitsubishi at the night of the shooting. He was never interviewed by the police, but he is telling his story to the jury on behalf of YNW Melly. Now, let's go into court and listen.
This young man was looking for his phone to call people.
Yes.
May I have one moment, please?
Yes, sir.
I have no further questions.
Counsel, is there any cross-examination?
Yes, Your Honor.
You're ready to make proceed?
Yeah. Mr. Davis, you said you're 100% sure that Mr. Demons found out at the same time you did.
Yes.
No questions about that. You're sure he was at that house?
Yes.
And you were upstairs?
Yes, ma'am.
He was downstairs.
Yes.
But you're sure he was there, you could see him.
Mm-hmm.
Is that a yes?
Yes.
And you are 100% sure his phone was missing?
Yes.
Where in the statement on May 5th did you ever say that?
Objection.
This objection.
It was never asked.
Thank you. Counsel, so I guess the objection is improper impeachment, so rephrase your question. That's just the
So,
objection.
you met with me on May 5th, 2022, you remember that?
Yes.
And you remember sitting down, you were present, that's a yes?
Yes.
Your two attorneys were present that you brought, that's a yes?
Yes.
And I asked you questions for quite a number of hours. Do you remember that?
Yes.
Okay. And do you remember being asked if you had met with anyone else with regards to this case?
Yes.
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
Yes.
Okay.
I didn't know who they were, and my lawyers told you that.
Okay.
I didn't know their names.
But you remember meeting with them?
Yeah.
Okay. And do you remember asking and being asked a question about what you talked about with them?
Yes.
Did you remember what you told them?
No.
Do you remember what you told them now?
Yes.
So are you telling this jury that when you were speaking with me, you forgot?
As in, what I'm telling them now, as of right now, yes.
So on the phone on that, do you remember if Mr. Demons had a passcode on his cell phone back then?
I don't think so.
You don't think so? And in terms of, would you be surprised to find that there was one on that cell phone?
No.
Did you know the passcode?
I don't think so. I don't even remember if he had one. We all use this phone sometimes. We all use each other's phones.
So you would use his cell phone? Why?
Talk to females.
You'd pretend to be him to get women? Because you couldn't get them on your own?
Objection.
Why would you use his phone then?
Let me rule before you ask the next question, all right? It's overruled. Go ahead, answer your question. Go ahead, ask your next question.
So, with regards to your living situation there, you were not paying any rent, right?
Oh, no.
And nobody was paying any rent in that house except for the defendant.
Yeah, I'm pretty sure.
So, do you remember that evening driving to the studio?
Yes.
You remember who was in which car?
On the way there, yes.
And you remember who was on each car on the way back?
Yes.
Okay. Were there any threats that were made to anyone that night?
No, ma'am.
Did anyone have any other conversations or discussions about threats from outside parties?
No, ma'am.
Was anyone worried about their safety?
No, ma'am. But Melly's a rapper, you know, he's always going to be a target.
I'm sorry.
I said he's a rapper, so he's always going to be a target.
Okay. And do you remember stopping on the side of the road?
Yes.
Where did you stop?
I don't remember. It's like flashes and blinks, drinking and smoking, so I just know we stopped.
You know you stopped.
Yeah.
And do you remember if that was on a highway?
Not at all.
Okay, do you remember if it was on a divided 4-lane road?
No, ma'am.
Do you remember if you guys were using GPS to get home?
No.
Okay, do you remember if you knew the route home?
No.
Okay. Do you remember what phone number you had back then?
No, ma'am.
You don't remember your phone number?
5 years ago, so.
Okay. Do you remember if you were awake or asleep?
Just told you. We were asleep.
You were asleep.
Yeah.
And you said you were intoxicated?
You didn't answer out loud.
Yes.
Do you know why the car stopped?
No.
Do you have any conversations or messages with the defendant?
No, ma'am.
Did you have a phone call with him?
No, ma'am.
When you stopped, was the gray Jeep in front of Red Mitsubishi?
Yeah, I believe so.
Have you ever answered that question differently?
I don't think so.
If I were to show you your statement from May 5th of 2022, would that help you in answering if you'd ever said something different than what you just testified in court?
Yeah, probably.
Okay, approaching with page 33 of the statement, counsel. And you just read silently to yourself.
One line?
Lines 18 through 20.
Yeah. I basically told you I don't remember.
Okay, so now your answer is I don't remember if the Jeep was in front or the Mitsubishi was in front.
If you watched the video, they put off first, so I remember it was in front of us.
Oh, so you watched the video.
You showed it to me.
In terms of the trial, have you been watching that online?
No, ma'am.
In terms of when you got home, you mentioned that you said Mr. Demons went to his room.
Yes.
Have you ever answered that question differently?
No.
Okay. On May 5th, 2022, remember that statement?
Mm-hmm.
At that point, did you say, I don't know where he went? I assume his room.
I don't know.
You don't. But looking at your statement, and I'll refresh your recollection on that.
Yes.
Okay, page 34, lines 12 and 13, counsel.
Yeah.
Okay, so did you previously give a different statement that you didn't know where he went and you were assuming he went to his room?
Yeah. He went into.
So with regards to the car, you're saying that you got pushed over when somebody got in the car?
Yeah.
Okay. And with regards to being pushed over, did you wake up when that happened?
Like it was flashes. Like yeah, I guess you could say I woke up.
Okay. And did they move you over or climb over you?
I don't remember.
Have you ever made a statement different than that?
I don't know. I can't remember.
Okay. Again, page 33. Question was asked: did they climb over to get you to the middle, over you to get to the middle of the back seat? Your answer was, I think I was at the window, so no. I think they might have climbed over.
Okay.
So, is it your testimony that somebody climbed over you, or you pushed over,
I mean,
or that you don't remember?
yeah, I don't really remember.
Prosecutor trying to cross-examine the defense witness Adrian Davis about whether he ever told her 4 years after the shooting about Melly not being able to find his phone. There was an objection on the basis that the prosecutor never asked that question that she was trying to impeach him about. Anyhow, there'll be more contentious cross-examination on the other side of this break. You'll have to come back to listen. YNW murder trial defense case. Adrian Davis, their star witness, still under cross-examination. Let's go into court and listen.
Okay. And in terms of the phone, right? Did you see anyone get into that gray Jeep?
No.
You remember going to Frito Bank's house?
Yes.
Okay. And you remember seeing the defendant there? Is that a yes?
Yeah, he was there with us.
And you remember leaving there afterwards?
Yes.
And you remember going back to the defendant's house?
Yes.
Okay. And you remember at that point that when you went back to the defendant's house, it was you, Travion Glass, or Fetty, and Jacoby Mouse. That's it?
Yes, I believe so.
Okay. And you said that you were in and out of sleep and intoxicated.
Yes.
And in terms of you remember that Travion was the last person to get out of the car?
Yeah, I believe so, yes.
Do you believe so, or do you remember? Which is it?
Yes.
And you know, and you mentioned about Mr. Demons looking for his phone, right?
Yes.
So of course he used your phone to call it and try and find it, right?
I don't remember.
You don't remember how he was trying to find his phone?
He just in the house looking for it, just like you would do if you lost yours.
So he didn't, try and find my iPhone or anything like that. Of course he used yours to do that, right?
I don't remember.
Of course he used something like, an Apple iWatch and set it off.
Objection, there's no testimony that he had it.
I don't remember.
Excuse me.
Okay.
One at a time. You asked the question. Objection noted. Overruled.
So of course he did all that. He went on, find my iPhone, and he's looking for it.
I don't know. I don't remember.
You don't remember. Okay. And of course he is using everybody else's phone to try and find it.
Before Anjanette Levy takes over to finish this examination and her questions and answers, let me go to you, Bridget Williams. Thoughts on this witness?
I believe this witness is extremely credible. He is a witness for the defense that is, I believe, is going to give Melly the not guilty verdict, that if he is going to get it, this is the witness that's going to give it to him. He has really just been speaking to what happened that night and to the facts with specifics. And he's the only witness that has testified about what happened exactly on that night. He's the only witness who was there in order to be able to give those facts.
Bob Hiller, 4 years before you even interview him, and as the prosecutor, not even the lead investigator. 4 years here. This testimony corroborates something. It corroborates the trip to Cortlen Henry to the hospital. Tell us why.
Well, yeah, because Henry showed up with the two victims at the hospital, but Melly wasn't with him. So, that's going to raise a question, I think, in the jurors' minds as to why. This sort of gives them an explanation as to why, and then they're going to look for inconsistencies in the evidence that might dispute that. And again, if the credibility attack is not an important thing, they're not going to really be focused on that minutia.
And Bridget Williams, we had Travion Glass also in the car, and there was a text to him that said that Melly said that he didn't do the shooting because it would have created a war. Then we found about a lost phone, and then we also have a text to somebody else where he used the word that instead of dat. How does that play into this testimony?
Well, there's been testimony from several witnesses that stated, one, that the phone was used by several individuals, not just Melly. And so multiple people had access to the phone. So that's the first thing. And then this particular text message, that doesn't necessarily even go to the fact that, something happened, that Melly was the person that did any shooting or anything along those lines. What I take from this is that this particular witness, again, everything else is circumstantial. This witness is the only one who speaks directly to the facts of what happened in this case, what happened that night.
Thank you. Thank you so much, Bridget Williams, for your concise analysis. Bob Hilley for staying with me for 3 hours here listening to all this incredible testimony. I'm Linda Kenny Bodden. I will see you tomorrow at 3. But stay tuned. Anjanette Levy and Ronan Suri up next with questions and answers.
Welcome to Law and Crime at this noon hour. I'm Anjanette Levy, and thanks for being with us on this Tuesday afternoon. We are covering the YNW Melly double murder trial, and the defense and the state have both rested their cases. And there's one witness, though, that the defense did call in this case. So we want to show you a little bit of his testimony. But first, just a quick recap. Because both sides have rested, court will be dark on Wednesday, and closing arguments in this case are scheduled for Thursday. Melly, whose legal name is Jamell Demons, faces 2 counts of first-degree murder and the possibility of the death penalty for the shooting deaths of his 2 friends. Demons' co-defendants, Cortlen Henry, claims Chris Thomas Jr. and Anthony Williams were killed in a drive-by shooting, but the state says the evidence shows the fatal shots were fired from the back seat, and they say Melly did it. Before we get into those viewer questions, and please keep them coming to us on Twitter, Facebook, YouTube, Threads, and Instagram, also TikTok, we want to jump back into court to show you that one and only defense witness, Adrian Davis's testimony. He was the only one, so let's see how that finished up.
I don't know.
You don't remember? Okay. But conveniently, the phone's missing that morning.
Objection to the
Sustained.
Yes.
I sustain the objection.
So with regards to your conversation, you texted back and forth with the defendant prior to this event occurring, right?
Yes.
And he had sent you a picture of his driver's license from that phone number.
Yes.
Oh. So you knew Mr. Demons, the defendant Melly, to use that cell phone 772-713-9807.
I don't know what the numbers is.
You had it saved in your phone, right?
Yeah, but I can't just remember that phone number like that from that long ago.
Oh. And your testimony is that he's looking all over the house.
Yeah.
So in terms of the phone, did you see it again that day?
I don't remember.
Don't remember. Okay. And in terms of the phone traveling up to the video shoot up in Cocoa, you don't know how the phone got up there.
I don't know.
And you didn't shoot Mr. Williams or Mr. Thomas, right?
No.
Okay. But you know who we're talking about, right?
Chris and Anthony.
Yes. And in terms of the messages and things for Mr. Henry, you're aware that his phone was broken at that time, right?
I don't know.
You don't know?
I don't know.
In terms of Mr. Demons, you know he was dating Mariah Hamilton.
Yeah.
Okay. And you know that Mr. Demons would FaceTime her on a regular basis.
Objection.
What's the objection?
There's no evidence of that.
I don't know.
So you know, and Mr. Demons would...
Excuse me, use the correct name.
Mr. Demons, my apologies. Mr. Demons would FaceTime and video chat frequently.
Yes, that's what you got a phone for.
And Mr. Davis, you never met with Detective Mark Knight? You never gave a statement?
No, ma'am.
And so the first time that you ever said anything about the phone being missing was today, July 18, 2023?
Yes, I believe so.
Okay. Nothing further yet.
Few questions.
Is there any regret? Go ahead.
Detective Moretti never even talked to you during this investigation, did he?
No, sir.
And the bottom line is, at the time you learned that Christopher and Anthony were shot, Sack and Juvy were shot, this man was at his house, correct?
Yes, sir.
And did you tell that to the state?
Yes.
And then were they the first ones who contacted you about this case?
Yes.
Thank you.
Is this witness excused?
Yes.
Sir, thank you very much. You may step down. You're excused.
So there you have it, Adrian Davis, one of the men who was at the recording studio that night. He left with his group of friends in the red Mitsubishi. Melly and his friends left in the Jeep Compass. But at some point in time, Adrian Davis says that Melly ended up getting into that red Mitsubishi. And he went through his recall and recounting of that entire evening. Then the defense rested. The state did not call any rebuttal witnesses. So there you have it. Before we get to your questions, I want to introduce our great panel we have with us to do that. And it's Law&Crime's Terry Austin. She has been covering the case for us down at the Broward County Courthouse. Brian Buckmeyer is a host and attorney here at Law&Crime. And also Imran Ansari is a host here at Law&Crime and also an attorney. So thanks, guys, for being with us today. Let's start with Terry. Terry, bring us up to speed on what exactly happened in court.
Well, it's interesting, Anjanette. I think everyone was expecting to see Brendan Collins, who was that FBI agent, as a witness because the defense was talking about that most of the week. And instead, we saw, as our viewers just saw, Adrian Davis. He was one of the individuals who was in that red Mitsubishi. He testified that all 8 of them, the 4 in Melly's car and the 4 in the Mitsubishi, were all friends. They all grew up together. They all lived in that house, and they were all collaborating on music at the YNW collaboration. And so there was no motive, essentially, is what the defense was trying to establish there for anyone to have any sort of shooting. We also heard him say that at the time of the drive going from the studio to the house, he basically said the cars pulled over and that Melly got into the red Mitsubishi. So when the shooting occurred, Melly was not in that car. He also established that they all went back to Melly's house. Melly was there. Melly went to his room downstairs. Everyone else went in other places. Then he said they got the phone calls that the shooting had occurred. He said they all cried. He said that Melly was crying as well. So they established that that did happen. One other thing, Anjanette, I'll say that I think Adrian Davis brought out on his direct testimony was when they did that video recording, you may recall, on the day of the shooting, and it is clearly after the shooting. Ultimately, that is what has been established. That was because he had to do the video. He explained that if he didn't do that video, he would not have gotten paid. So he explained why we saw that video shortly after the shooting, where everyone was, walking around, and you saw Melly. He was preparing to do that video. So I think it was a crucial witness for the defense, and I think he came across as credible. And the prosecution did try to say, look, I took statements from you. You didn't say all of these details. You said you weren't sure where Melly went when we went in the house, but they did what they could, I think, on the cross of that witness to establish that his memory wasn't exactly clear. But at the end of the day, this is a live witness. It is not circumstantial. It is direct. It is someone who was there that night, and I think it had a powerful impact on that jury. They were at the edge of their seats listening to this witness.
Yeah, very interesting. It's always nice to hear from a civilian rather than an expert or law enforcement. We heard from so many experts and members of law enforcement in this case. There really weren't many, regular people, what they call lay people. So thank you so much, Terry, for that. Let's get to our questions now. We have a lot of really good ones coming in as usual. So keep them coming on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads. And we'll get to as many of them as we can over this hour. This first one I'll send over to you, Brian Buckmeyer. AMJ Gaming 101 ! Asks, do you think the jury will buy into the drunk/high story or believe it to be an excuse for his selective memory?
That one's tough. I think it comes down to a number of things. One, who's in the jury? Do we have a jury full of people who would recognize these kids as being people who would be like, yeah, they're rappers, they're young, they're knuckleheads. Of course they're gonna get drunk and high. And of course, after a recording session where they're up to 3 o'clock in the morning and they're celebrating, they're working in this environment, we see it in their music videos. It seems like that's what their night would be like. I think it does make sense and I think it would work, but would it work specifically to his selective memory? That's the real question. But I'm not sure if the prosecution opened up the whole of these guys are incredible, meaning not credible, and you shouldn't believe them. I think they just got an alternative story that didn't really work for the prosecution.
Our next question, Imran, comes from @my2cents89 from Twitter, and he's asking about Adrian Davis's testimony. The one and only defense witness will remind everybody watching. Today's witness said exactly what YNW Melly needed him to say in order to make the defense's theory plausible. Reasonable doubt? Hardly. His testimony was in no way credible. What's your assessment of that, Imran?
Well, you have to think that this is the last piece of testimony that this jury is hearing. And I think it's going to resonate for a number of reasons, including the fact that this is one individual who can place himself at the scene, or at least with YNW Melly when this shooting occurred, and he's giving that jury testimony, which sort of divorces YNW Melly from that vehicle, takes him out of that vehicle, and that could be the reasonable doubt, that one sliver of reasonable doubt that the defense needs in order to prevail and get an acquittal, or at least a hung jury here with a juror or two not finding for the prosecution. So I think that even though there may be some credibility issues with this witness, it could be argued by the prosecution that he's giving testimony of convenience, if you will, to support his friend YNW Melly. It also may be just what the defense needs to have that reasonable doubt to get over that conviction.
And some of what he said appears to be contradicted by the cell phone records. So the defense has said that cell phone was a communal cell phone. It was shared. So it'll be interesting to see how that is addressed. Let's take a quick break, and we will get to more of your questions when we come back. Stay with us and keep the questions coming on all of our social media platforms. I'm Anjanette Levy, and you are watching our lunchtime Q&A on Law and Crime. We'll be right back. Welcome back. I'm Anjanette Levy, and you are watching Law and Crime. We are taking your questions during this lunch hour. It's not really lunch hour in the YNW Melly double murder trial anymore because both sides have rested. The defense rested this morning after calling one witness, a civilian, Adrian Davis, who was at the recording studio that night, riding in that red Mitsubishi that left the recording studio around the same time as the Jeep Compass involved in this case did. So we are taking your questions. Closing arguments are scheduled for Thursday. Court is dark tomorrow on Wednesday. So Terry, I'm going to get this next question to you. It's from TikTok. @AngelsFace82 asks, why did the defense wrap up so quickly?
Well, I think they wanted to end with a bang, so to speak, and they had a civilian witness. They had a witness who was in one of those two cars, and it was Adrian Davis, and he was able to testify direct evidence about what occurred that night, and he did give some very helpful information as far as the defense is concerned. He stated that both of the cars left the studio, that they were driving home to Melly's house, that they pulled over, and Melly got into that red Mitsubishi, so he was not there during the shooting. They went home after that. They got a phone call, and the phone call was about the shooting, and they all were very upset. So I think what the defense strategy-wise was trying to do here is to end on a high note. No reason to call a crime scene reconstructionist, I'm assuming, because that could go back and forth. It's an expert. Who's going to believe your expert over the prosecution's expert? So why even bring that back into the case? They were also considering bringing Brendan Collins, who's an FBI agent. He was going to talk about those cell phone records. I'm assuming the defense was probably thinking the jury has already heard enough about that. So they ended with a witness who I think was pivotal as far as this case was concerned.
All right, Brian, our next question, also from TikTok, and I think it must be from AngelsFace82 because it says, thank you. One last question. Did Melly make a mistake by not testifying?
Ooh. I don't think so, because I think at the end of the day, what the defense is doing very well is this isn't necessarily this story versus this story type of case. I think that what they're going for is the prosecution can't prove their case. I think in this situation it works because you have the type of crime where you're alleging that your client wasn't there. It's different than a self-defense argument, for example, where you're not saying your client isn't there. In fact, they're part of it, but they have to justify their actions. I think the defense is being very wise, as Terry articulated, in just removing him from the equation altogether. So I think at summation, they can argue, if he was to testify, what would he have told you? That he got in the Jeep at some point, and then he got out, and that when he found out the news, he was with Adrian Davis, and he wept and he was cried about it? You already know that. So what could his testimony advance other than to have this prosecution cross-examine him about the death of his two friends that he's being wrongfully accused of? I think that's the angle the defense can go and probably should go with putting on the defense just like that. So in that sense, I think a pretty wise move not to testify.
Imran, our next question comes from @T_Kellis from Twitter. So say Melly is found not guilty. Could he testify at Bortlen's trial, take responsibility for the crime, and not face repercussions for his testimony / admission of guilt?
Right now, under the theory of double jeopardy, that could be a plausible sort of scenario there, but it would be somewhat outlandish, and I would not expect YNW Melly, even if that was the case, to go in and help Bortlen like that with that sort of testimony. Could he be a witness at that trial? Yes, that's a possibility. But again, if I was his attorney, I would be looking to distance YNW Melly from this crime after an acquittal, if that happens, in every way possible. There could be a subpoena, and he may be compelled to testify at that trial. He may be a witness for even the prosecution if they're going to somehow bring him in as a witness. But again, if I was YNW Melly's defense attorney and he got acquitted in this case, I would be looking to distance himself in every way possible from any other proceedings.
Mm-hmm. I like this question for you, Terry. Latasha Gaffney, who I've seen that name quite a bit from our YouTube chat, so thanks so much, Latasha, for all your good questions. Could it be that both cars were on the scene when Juvy and Sak were killed, and that's how Melly got into the other car and left his phone behind, rushing to get off the scene? So there are a lot of ways we could answer that question, but Terry, what do you have to say about that?
Well, I think it's an excellent question, and certainly the prosecution can argue that. I mean, they were arguing that it was Melly who actually did the shots from the back seat, so I don't think at this point they're going to change any theories that they may have. But it's up for that jury to decide, and so the question you raised, Latasha, is reasonable doubt. I mean, it's reasonable doubt because we don't know exactly what occurred. We know what this witness said today, Adrian Davis. He said Melly got out of the car. He said Melly went into the red Mitsubishi. But if something else happened, that's up for that prosecution to establish definitively one way or the other. So I think there's some reasonable doubt here. I think at the end of the day, the jury's going to try to determine what was credible, what was not. I think Adrian Davis did have some moments where he wasn't 100% sure based on what he was saying earlier during an interview with the prosecution and what he said on the stand today. But I think the major points he was very clear on, and I don't think the prosecution was able to sway him one way or the other that that's exactly what happened that night. Melly got out of the car. They went back to Melly's home. He wasn't there. He was 100% sure, according to the defense, that he was not there. Melly was not there during the shooting. He was at that house.
Brian, I guess I have a question I'm going to throw over to you based on that. How are they going to explain then, and I understand the defense has no burden here, they don't have to really explain anything, but the cell phones, you know, if you look at the diagram that was presented through the FBI agent's testimony, they travel together and then at one point they diverge that night. You know, the one cell phone, you know, or set of cell phones goes to the house, the other one goes to that 27 in Pembroke Road crime scene.
I guess the argument there is that at some point in time, since we don't know where the shooting occurred, is that when that second cell phone goes towards Pembroke, that's where the shooting occurs when they split. Because no one's been able to give us an actual timeline for when the shooting happened or the actual location. They weren't able to go back and say, hey, we know it was shot from the inside out. Here is a bullet that landed in a home, or here is, well, it'll be shell casing because they probably land inside the car, but we don't know where the shooting is. So yes, you have great information that the two cell phones traveled together and they separated at one point. I think the argument can be, if I'm correct in this, the cell phone that travels to the house is YNW Melly. And as he's getting to the house, he's pulling up, gets in with Adrian Davis. They start getting phone calls. Both stories can be true. I don't think they need to be that combative. It just needs to be that the timeline isn't perfect because the prosecution hasn't given it to you.
But the Melly phone does go to US 27 in Pembroke Road.
So then the argument would be that the other phone going away towards the house is where the shooting occurred. It's simply a matter of the shooting happened when the two cell phones separated. And if they can't prove to you that the shooting happened when the two cell phones were together, then how are they proving that Melly was there during the shooting?
All right, our next question, and I will stop with my questions, comes from Threads. Imran, Curated Adventures Travel from Threads asks, why did they go to Fredo's house instead of the hospital if they were so close?
That's a good question, but it's a question that I can't necessarily answer because I wasn't with them. You know, that is one question that may arise in the jury's mind, and we'll have to see if during summation that's going to be explained to them based on the evidence that is before them. But you know, that is a good question when you're thinking about why they would proceed to one location rather than the hospital. But again, that's going to be one piece of evidence among a slew of evidence before this jury that they're going to have to decide. And whether they have proven the case beyond a reasonable doubt, I mean the prosecution, and these answers are then either answered by the prosecution in summation while they sum up that evidence, and then also the defense has also their theory to present to the jury. They will have to decide, and that's one question I think that may also arise in those jurors' minds.
So Terry, we have a two-part question coming up for you. This is from @JustChillin' from Twitter. If Melly should be found not guilty, what will that mean for the trial against Cortlen? So we'll throw that part at you. And then the second part is, why could it be exonerating for Melly that he was looking for his phone when they were at the house?
Okay, so as far as the first part is concerned, if Melly is found not guilty here, and then Bortlen obviously is going to be tried. He's already scheduled for trial. I think that is going to not help as far as Bortlen's case is concerned, because that jury is going to be pointing that finger only to Bortlen. And if Melly is already acquitted, then the jury is not going to be looking at any other possible defendants in either one of those cars, particularly, though, as it relates to Melly. So I think because the prosecution has already decided it was one or the other, obviously they brought the case against both of them. They brought the case against Melly as a death penalty case because they thought that he was the shooter, and that's why they have the death penalty against him. They said Henry because he was the driver in the car, he survived. So if Melly's acquitted, it's not going to help Bortlen as far as his case is concerned. He's the last person standing, so to speak, in that car. As far as looking for the phone in the house, after they left the studio, they drove back to Melly's house and they pulled over the side of the road. According to Adrian Davis, Melly got out of the car, got in the red Mitsubishi, went to the house. They got the phone calls from various people. It wasn't established exactly whom, but they got phone calls about the shooting. And Melly apparently wanted to make some calls out. He was looking all over for his phone. I think that's important because it shows where Melly was. He was in the house. He wasn't with his phone. He wasn't at the shooting. And he was upset like the rest of the other people in that house. It's basically saying, look, it's a person who's not with that phone, so he is not the one who actually did the shooting. So I think it does help Melly's case that he's looking for his phone at that point in time.
Brian, J. Allen Day from YouTube asks, by the defense not bringing in their own forensic expert witness to give the jury a different opinion on the shooting and how it occurred, did that weaken the defense's case?
I think it depends on how the summation goes, because in my mind it goes one of two ways. Either they're going to go up there and they're going to really wrestle in the mud with this expert and say they were wrong here, they may have been right here, and whatever it may be. I don't think that's the smartest road to kind of travel, because you could argue it somewhere else. You could say YNW Melly never said the shooting happened from outside the car. That is a lie from Bortlen. That has nothing to do with Melly, because as Terry eloquently said, he was at the house looking for his phone. He wasn't there. So whether or not the shots came from inside out or outside in and who lied about it has nothing to do with Melly. Take that up with Bortlen on his trial. I think that second option is a lot cleaner, and that's probably why you don't bring an expert rather than bringing an expert and having this battle of the experts.
Yeah, the battle of the experts, sometimes it's a wash. I mean, sometimes people just go with their gut on this and don't really pay attention, and other times they're really effective. It just depends. Imran, I've got a great question for you coming up, but first we have to take a quick break, so stay with us and keep the questions coming on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads. We'll get to as many of them as we can when we come back. We'll be right back. Welcome back. I'm Anjanette Levy. Thanks for being with us on the lunch hour here at Law and Crime. We are taking your questions on the YNW Melly double murder trial, so keep them coming into us on all of our social media platforms. The state and the defense have both rested in this case. The defense calling just one witness, Adrian Davis, who was at the recording studio that night. And so court will be dark tomorrow, so both sides can prepare their closing arguments. Those arguments will be heard by the jury on Thursday morning. So, Imran, I said before the break that I had a question coming up for you, and I do, so let's get to it. Teak, exclamation point, from YouTube asks, what would be the real reason, in all caps, for Melly to switch cars mid-trip to the house if both cars were going to the house?
Right. Well, you know, that question is left unanswered by the evidence in the record. I mean, there could be many theories or reasons why he would switch cars, but this jury doesn't have it in testimonial or evidentiary form. They're going to be told by the judge they have to listen and decide this case on the evidence and the evidence alone. They can't speculate. So that may be one point for the defense that may be a negative because they put Williams on. He testified that Melly ended up in that red Mitsubishi, but the reason why that switch occurred is left unanswered. And that may be something that the prosecution will hone in on in summation and point that out, like why would that happen? And it may be something the defense would have to grapple with. And remember, the jury can't speculate. They have to make their decision in this case on the evidence and the evidence alone, and that's why it may be something that may hurt the defense in the end.
Terry, curated adventures travel from Threads. So they're sending in some good questions too. If Melly was in the red Mitsubishi, why did he send Fredo Bang his location from the reported crime scene? Why didn't Mr. Glass? Okay, let's start with part one of this question. This is one of those multiple questions. One, if Melly was in the red Mitsubishi, why did he send Fredo Bang his location from the reported crime scene?
Okay, so like Enron said, this is one of those pieces of evidence that is not there for that jury to consider. We don't know exactly why. If, in fact, maybe he was sending it for Fredo to pick him up, maybe Fredo Bang couldn't pick him up, and so he decided to get in the red Mitsubishi. Maybe the, gray car was going someplace else before going back to Melly's house. This is all speculation. I don't know. Those questions have not been answered into the evidence, so the jury isn't going to be allowed to speculate on that issue. So as far as the first part of that question is concerned, Anjanette, I don't know why he would send the location to Fredo Bang if in fact he was getting in another car. I just can only assume here, as the reporter looking at the trial, that he had to get in the red Mitsubishi instead.
Okay, and I'll send you the second part of the question, and Brian, then I'll get over to you in a minute. But why didn't Mr. Glass, Travion Glass, know that Melly was in the car with them if he really did get into the Mitsubishi? So we've got two lay witnesses basically telling two stories.
That's right. If you recall, Travion Glass came on earlier on the prosecution's case, and Travion Glass basically did not add a lot of substantive information. He didn't clarify, at least not to the extent that we saw Adrian Davis clarifying who was in which car. Davis clarified clearly who was in each of those cars. I think Travion Glass was a little more vague about most of that information. I said this before. One of the things he did say was that there was a change of clothes by Melly, but other than that, he just didn't recall. I think we heard testimony that they were all drinking and smoking, so perhaps he just could not remember. So that's probably part of the reason for the inconsistencies as far as who's in what car.
Travion Glass, much like Felicia Holmes, did not want to be there. It was very obvious. Brian, Ava Grace 467-639-69 from Twitter asks, how does the testimony of this witness, and I'm assuming they mean Adrian Davis, line up with the forensic evidence from a few weeks ago?
So I'll try to narrow it down. I don't think it lines up in the sense of it gives a nice storyline that goes side by side. I think this storyline actually diverges a little because now the question becomes, if YNW Melly is not in the vehicle at the time of the shooting and there's only 3 occupants in that car, and you have one driver, one front passenger, and then one person in the back, who's shooting from that seat behind the driver? Are we now saying that one of the victims, someone who died, was back there? And maybe this was a shooting between the two victims shooting at each other? Maybe that would explain it. But taking out one person out of this car where the prosecution is saying there was 4 does kind of go against, at least to some degree, what the evidence shows. Because I guess hypothetically, if I'm the person behind the driver's seat and I'm shooting across and they're shooting at me, maybe some bullets go here in straight across from me as well. Maybe we're moving and we're not stationary objects shooting at each other. I guess that could make sense, but I think Terry and Imran have already said it, and I'll say it even in a different way. If we get to a point, and let's pretend we're jurors, if we get to a point where we have questions and we can't piece it together to make sense, what I tell jurors, I make the analogy of, imagine going to a restaurant and you order a meal and they mess up your meal. Sure, can you go back in the kitchen and fix that meal to get the steak the way you wanted it cooked or the vegetables steamed the way you wanted to? Yeah, you probably have the ability to, but no one in their right mind goes into a kitchen of a restaurant they just ordered food, fix the meal, and then eat it there and then pay the bill. No, you leave. And the jurors should be doing the same thing. If they've got a menu of food that doesn't make sense, don't put it together to find guilt. The law says that's not guilty. Imran, I see you shaking your head. Use the analogy. It works.
Absolutely agree.
I just want Brian, Imran, I'll let you stop talking in a minute, but I want Brian to stop talking about food. I haven't had lunch yet, so go ahead, Imran.
No, Brian makes a great point there. If the juror is left with these questions, and they're questions that go to the heart of the elements of the crime that YNW Melly is charged with, then that's a problem, right? That's reasonable doubt right there, because the prosecution hasn't met their burden by giving that jury the answers to the questions, right? The defense, they don't have a burden. They want, as a defense attorney, you want to put on a case if you need to, right, in justification, like Brian mentioned before. But you really want to poke holes into the prosecution's case. And based on what we're hearing from these questions, it sounds like if our viewers have these questions about the evidence, and assuming they've been watching diligently here at Law&Crime this trial, then that means that jury may have those questions. And if they have those questions, that's going to bode very well for the defense. But it's the defense's job to hit that home in summation and let the jury know that if they have those questions, they're unanswered, that equates to reasonable doubt. They haven't met the burden in the prosecution's camp, and they should come back with an acquittal.
Terry, our next question comes from @RikerJS. How do you think the defense handled some of the evidence that could go against Melly? This is from TikTok.
Well, if you remember the beginning of this trial, they had experts on guns, they had experts on DNA, they had experts on the cell phone towers, and they had an expert on gang. I think on cross-examination, the defense dealt with those issues. As far as the gun is concerned, there was no gun residue on Melly. As far as the cell phones are concerned, they're saying, look, you can tell us where the phones are, but you can't tell us exactly where Melly is. The gangs, they dealt with that issue by trying to say, look, they wanted him in the gang. It's not Melly who was trying to get into the gang. He basically ignored most of their messages. And as far as the DNA, there's no DNA except on the outside of that car. And I think what the defense was trying to say for the DNA is, look, okay, he opened the door. You saw him open the door, get into that car at the studio, but that doesn't put him inside the car with the gun shooting from the back seat. So I think the best evidence that the prosecution had were in those areas, as I just mentioned, and I think the defense dealt with it by trying to dispute exactly what the prosecution was going to say.
All righty, we are going to take a quick break. Keep the questions coming in on all of our social media platforms. We'll be right back. Welcome back. I'm Anjanette Levy. Thanks for being with us here on the lunch hour on YNW Melly's double murder trial. It's really not the lunch hour, I guess. I guess it kind of is in that trial, but both sides have rested. The defense calling one witness today in defense of YNW Melly. Court will be dark tomorrow. There will be arguments, I think, about jury instructions in a little bit here. And then closings on Thursday. So we'll see what happens there and what the jury decides in this part of the trial, whether they come back with a guilty, a not guilty, or possibly a hung jury. We're taking your questions, so let's get right back to it. Brian, based off of what you've seen, what do you think the verdict will be, and does Melly have a chance? This is from @GoatBabaJ from Twitter.
All right, go Baba J. I think it heavily depends on the prosecution. It really depends on them, because this is the way I'm thinking it. Okay? For me, it's not just a straight answer. The prosecution gets the last word, meaning the defense gets to have their closing and the prosecution goes last. Correct me if I'm wrong, I think in Florida it's prosecution, defense, and prosecution, but prosecution regardless always gets the last word. And the question becomes, is the defense capable of addressing all of the issues the prosecution can bring up when they get the final word? If they can, and the prosecution can't, for example, answer all of the questions that all of our viewers have been asking, why get out of the car at this point? Why switch cars? Why this? Why that? If they can't address that, and the defense has the ability to say, as Imran said, those whys equal reasonable doubt. Reasonable doubt equals not guilty. I can't see an avenue in which the prosecution can weave their way out to a guilty verdict. However, there are those people on the jury who'll be like, guys, this is simple. We could piece it together. We could do it ourselves. And so what I'm leaning towards is probably, if I'm throwing out numbers, a 9-3 to acquit, anywhere from there, or full acquittal. I think there might be a few holdout. Maybe it'll take some time, but I think eventually they get this past the finish line if those things happen.
All right, our next question is coming from Des from YouTube. Imran, do you think Bortlen will try to take a plea deal if Melly is found guilty or not guilty to not go in front of a jury?
I mean, that would be a reevaluation of his situation by obviously himself and his attorneys, and certainly the verdict in this case is going to spell out the game plan in that case, right? So he may very well look at this case, if there is in fact a conviction, and start reevaluating his decision to go to trial. And if there is an offer by the prosecution, his attorneys would sit down with him, and I would imagine they would seriously consider taking a plea if this trial goes south for Melly. Now, again, he stands in a different situation, in different shoes than YNW Melly, but of course these are facts and a trial stemming from the same incident. So this is almost a litmus test, if you will, for the Bortlen trial and for his attorneys, and I'm sure they're watching intently, listening to all the evidence coming in this trial, and the verdict in this case, I am sure, will be something that they will consider when they consider their next move. A, go to trial still, or B, if the prosecution is offering something, will they consider it?
But Imran, wasn't the time to make a deal before Melly's trial started?
That's a conversation which probably the prosecution had with Bortlen. If any offer, any plea deal was on the table and now it's off the table, then that's something that's going to be considered, and he may be going to trial regardless. But also with either a conviction or acquittal in hand, the prosecution themselves may reevaluate the case and decide whether they're going to offer something, if they could get a conviction in hand with Bortlen now that they have a conviction with Melly, or if there's an acquittal with Melly, reevaluate the case now that they've had that trial run with Melly, and say, let's offer Bortlen
Go further.
All right, let's get to our next question. At Jamie, well, at _ Jamie _ W _ that's a lot of underscores in one handle. From Twitter asks Terry, if the phone in question, allegedly Melly's phone, was left in the car by Melly, did it ping the same towers as Cortlen Henry's phone leading all the way up to the hospital? That would prove if the witness for the defense is credible or not. But Bortlen, Terry, didn't have a phone that night.
Well, that's right. The 2 phones or 3 phones in that car, at least according to the testimony, were phones that were Anthony Williams and Christopher Thomas, and then there was a third sort of burner phone. So there was no phone by Cortlen Henry in the car, at least at that point. And as far as Melly's phone, it wasn't in the car at the hospital because, you know, it was elsewhere. He was looking for it. So it's unclear to me whether or not, to answer the question, they can tie all of those phones together. I think the cell phone data has been something that has been a bit confusing for the jury, and following all of the telephone numbers and figuring out who owns, you know, the 9807 phone and who owns the other phones and where those phones were this night. It's a bit unclear. The only thing I think that the jury is going to understand is that the victims were in the car, their phones were in the car, and there was a third phone found in the backseat that wasn't the 9807 phone. It was another burner type phone that was in that car.
Brian, we only have about a minute and a half left in the show, but this comes from Taylor from YouTube. If Melly lost his phone, how was he dropping pins and FaceTiming and texting later that night? Really briefly.
That's a great question. I don't know. Maybe he found it at some point and maybe Adrian couldn't tell us. But again, that comes down to one of those questions that if the prosecution can't answer, a wise and very articulate defense attorney would say, more questions, more doubt, more not guilty.
All righty. And now we actually have time for one last question, and it's going to go to you, Imran, and I need you to be brief as well. At Zach0988 from Twitter, when is the verdict?
When is the verdict? It's a good question. Let's see what summations, how they, you know, both sides put their summations out there. I think that's going to be telling on how the jury will react to that. But I think that, I actually think it's going to be a well thought out verdict. I don't think it's going to be necessarily a swift one because you got a lot of evidence from the prosecution to sift through.
Yeah, a lot of evidence. I mean, there was a lot of expert testimony. We had the cell phone stuff. We had a couple of lay witnesses, a lot of police officers coming through to testify. So there's a lot to discuss, and they've been going at it now for over a month. And then we had a couple of delays as well. So there's a lot to recall in this case. It'll be interesting to see how both sides sum it up. So we are done here for this hour. We really appreciate everyone tuning in, sending your questions as usual. As I mentioned, Thursday, we'll have them covered here. Terry, thanks so much for being with us. Brian, you as well. Imran Ansari will take it from here after we get back from the break. So stay tuned right here to Law and Crime. Throughout the afternoon, we'll bring you the very latest on the YNW Melly double murder case.
State attorneys, the jury is excused for the day. We're going to go with the jury instructions. So this is the charge conference. So I know earlier I was provided a set of the proposed jury instructions, and you have those too. Is that correct? Who's handling this for the defense?
Yeah, we do have them. I think there may have been some edits to that you received.
Going to replace everything from count 1 premeditated murder all the way to page 1 of manslaughter count 1.
So I'll insert those as we go, all right? And Howard, you have everything, yes?
Yes, I'm about to get the supplements.
So, first one I have is 2.7 closing argument. Your objection, state?
No, Your Honor.
Defense?
No, sir.
The next one I have is the 3.1 introduction of final instructions. Any objection, state?
No, Your Honor.
Defense?
No, Your Honor.
And I have 3.2 statement of the charge. Any objection, state?
No, Your Honor.
Defense? Then it starts out with 7.1 introduction to homicide. Any objection?
Not for this name.
No, Your Honor.
The next one I have is 7.2 premeditated murder first degree. Now this is the one that's been substituted, is that correct?
Correct.
Actually, Your Honor, back at 7.1, the second page of 7.1, at the very last paragraph, first line, where it says, I now instruct you on the circumstances that must be proved before Jamell Demons may be. We would like it to read, I now instruct you on the circumstances that must be proven beyond a reasonable doubt, as opposed to proved.
Thank you. And
Judge, I'd like to make another argument regarding this section. We would suggest that the actual superseding indictment in this case reads in pertinent part. The defendant did unlawfully kill the victim, the defendant committed the offense for the purpose of benefiting or promoting the interest of the gang.
That's the
We're not there yet.
We're going
Oh,
there.
I'm sorry.
Yeah.
Going there.
As to that second page of 7.1, Your Honor, this is the standard introduction homicide instruction. It reads as...
And you don't disagree with that, you just want to word it a little different, is that correct, Mr. Howard?
Yeah, it says proven beyond a reasonable doubt is the standard of law, so we would ask that that be substituted for the word proved. I think that would set the way the jury needs to be reminded further.
Thank you. Objection, no, it's overruled. All right, we use the standard. Then comes up 7.2, premeditated murder, and this is the one that you've amended, correct?
Correct, Your Honor.
And it now has count 1, 7.2 premeditated murder first degree. Am I correct?
Yes.
And have you seen that, Mr. Howard?
Yes, Your Honor.
Is there any objection to this?
Ms. O'Shea is going to make the argument.
Judge, as I was saying, the superseding indictment is worded, I think, in a rather interesting way because it suggests that the proof needs to be the proof of premeditated murder. And the way that the indictment is worded, it says, and the state must prove that it was also for the purpose of benefiting or promoting the interest of the gang. It would suggest, Your Honor, what the superseding indictment does in effect is it adds two more elements to premeditated murder. And in order to prove premeditated murder, then the state would have to prove that the victim is dead, that the death was caused by a criminal act of Jamell Demons, that there was premeditated killing, and that as well, there'd be a fourth element that says he was a member of a criminal gang, and a fifth element saying that it was done in furtherance of that criminal gang. So we would suggest that that is all part of the state's proof regarding a conviction for premeditated murder. The way that it is charged in the indictment is obviously has to follow. This argument would continue and be charged this way in both these sections as well as in second-degree murder, manslaughter, and felony murder. So this objection would go to all the appropriate sections of the charge.
Thank you. And what's the state's position on all of this?
The state would say this is an aggravation, not an element. In support thereof, the state would cite to Richardson v. State.
I don't think she's disagreeing with that. I think she's suggesting it's not, that it's typically it's not an aggravation. She's saying, the way I understand your argument, counsel, you're saying is how it's worded in this case is incorrect, and therefore it's more than an aggravation. It's something they're alleging should be basically creating a new element or something to prove.
That's correct, Your Honor. And if I can just add, it's really, although it's generally a gang enhancement, I mean, what can we really enhance here? We're talking about a first-degree murder charge. There is certainly an aggravator in the death penalty section of this for gang enhancement, but as far as first-degree murder, I mean, what can you possibly enhance that to?
Mr. Your Honor, in support thereof, the state would cite to Richardson v. State, 338 Southern 3rd, 1106. That's a 2022 case. It is a first-degree murder by a criminal gang member. So I'll give Your Honor a copy of the affirmed opinion in that case, as well as the indictment, the jury instructions as to count 1, the first-degree murder, as well as the verdict form as to how it was written in that case. Those have already been provided to defense counsel.
And if I can just add, Judge, for the Richardson case, this was never brought up on the field. I don't know why it was never a question, but it was never brought up on the field. So it really wasn't addressed in the appellate opinion.
Counsel, I apologize, but I know what I do with my copy. You got an extra one there?
Yes, sir. And I also sent 3.14, which is the discussion of score sheet findings for aggravators and things of that nature, which furthers the state's position that you cannot add an element to that. And there's actually a standard instruction for criminal gang as a criminal punishment code score sheet enhancement as part of 3.14. I'm handing a copy to the court and defense counsel.
Unfortunately, Judge, the indictment did exactly that. It added this as an element. And the indictment is what we have to try.
So Your Honor, for that to be a correct statement, and for defense counsel would then have to also argue that the actual possession or discharge of a firearm was an additional element of the homicide, of which it is not.
Thank you. And I understand what the argument is. They're suggesting that the way it's been worded is not an enhancement, it's actually making it part of the offense, the way the indictment is worded. And, all right, so I understand what the argument is. Is there anything further? No, that's, your objection is overruled. I think we're going to follow the standard instruction and treat this as an enhancement, not as an actual element of the offense of first-degree murder. So, in any event, objection notice overruled. So what else? What other arguments are there regarding premeditated murder, first-degree count?
Regarding 7.2, Your Honor, on the third page where it goes to criminal gang member, at the end where it has the enumerated or the alphabetized.
A through I or whatever?
Yes. The problem with this case, Your Honor, is twofold. One, we had a witness who testified as an expert in contravention of some of these statutory requirements. He indicated, now here it says that a criminal gang member is a person who meets two or more of the following criteria. But as the testimony was adduced from their gang expert, somebody who wears red and throws up gang signs is not necessarily a gang member. So we have a testimony from their expert, the state's own expert, that contradicts the statute in terms of what is required for the jury to make a finding of criminal gang membership. Beyond that, so we would object to Section B, which indicates one of the criteria being adopts the style of dress of a criminal gang. In other words, wears red. I think that is dangerously prejudicial to give to a jury. C, adopts the use of hand sign identified as used by a criminal gang, which we already saw. We have everybody from 10-year-olds doing it on YouTube all the time, so that is notwithstanding what the statute says. The evidence that's adduced in this case would make this jury instruction misleading. I think subsection E associates with one or more known criminal gang members. I think is constitutionally offensive to the extent that it kind of ignores the fact that people grow up in neighborhoods and have friends and what have you who take different paths in life. And the notion that unless you immediately dissociate with them, you are a member of whatever gang they joined, I think has socioeconomic and racially, constitutionally offensive implications. And finally, with respect to Section H, which says, has been observed in the company of one or more known criminal gang members for 4 or more times. The evidence that the state put on, they denied that either of the 2 decedents were gang members, and they put on pictures of Mr. Demons at concerts, taking pictures with fans who may or may not have been in the gang, may or not have been wearing red. But I'm in a fraternity myself. If I see Kevin Costner and I take a picture with him, it doesn't mean that he is therefore in my fraternity. So particularly where we have a situation where we have a celebrity who is prone to take pictures with fans of all walks of life, to invite this jury to conclude that the pictures that the state put up of him taking pictures at concerts with people is sufficient for them to find gang membership, I think, is misleading and improper. So we would object to subsections B, C, E, and H on those grounds.
Thank you. What's the state?
Judge, the standard jury instructions essentially list a host of different options that the jury can find. The jury can agree or disagree with the defendant as to B, C, D, E, or F. These are all conform to the testimony of Detective Dan Polo. So that's why the state left all those in subsections. Specifically, you recall the testimony where he spoke about the color that the gang members wear, the different type of hand signs. He talked about different hand signs displayed to the jury. He talked about the defendant's associations with known criminal gang members, including what was evident in the text messages in the 9807 phone number, and also again with the observations of other individual gang members within the numerous photographs that were displayed throughout Detective Dan Polo's testimony.
Is there a standard instruction on? There's not.
No, Your Honor. With the assistance of the Richardson case and the Florida statute 874.03, we created these instructions.
And does this mirror the Florida statute 874?
Yes, Judge, it mirrors 874 subsection 3, which defines criminal gang membership, and it goes A through K, and we did remove, I think we removed K, which states, for instance, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. We also removed is identified as a criminal gang member by a parent or guardian, because that did not come forward with the testimony.
Thank you. Anything else?
Stand on that argument, Judge.
Thank you. Objection notice overruled. As long as this mirrors what the statute is, it means that there's evidence from the detective regarding each one of these. The objection notice overruled. That's as far as count 1, 7.2. Any additional issues with count 1?
No, sir.
So it's the same issue with count 2, correct?
Yes.
And you're preserving that, but it would be the same ruling. I'd allow it.
Understood.
All right. The next jury instruction you're looking to have the jury instructed on is 7.3 felony murder. Is that right?
Yes, sir.
Yes, Your Honor. The state gave you defense counsel the Pierce case this morning, as well as a memorandum of law that discusses the other times Pierce was cited. Defense counsel specifically asked if I had any cases in which the felony murder was, or the murder of another human being was the underlying felony. So I'm providing Lynch v. State 2 Southern 3rd 47. It's a 2008 case with the Supreme Court of Florida, and it starts on page 14 of the printed copy and goes into page 15, which discussed that specific scenario in which another murder was the basis of the underlying felony for that. And there, with regards to the Pierce case, it's well settled in Florida law. The Pierce case is, I believe, 1995 or 1997. That has cited that has been the state of the law in Florida, where as long as the defendant is charged with murder in the first degree and there is a limited number of felonies under which the state can proceed, that is sufficient notice. As well, it goes into the fact that Florida is a very liberal state when it comes to discovery. Defense counsel has been aware, as all parties are aware, that there are 2 individuals that were killed during the course of this homicide.
Yes, Your Honor, we're not arguing a lack of notice. What we're arguing is that the state's interpretation of during and in the course of another felony deviates from common understanding of those terms and the definition of those terms in the English language. If, for example, I attempt to shoot one person and I end up shooting another, then I have killed that second person during and in the course of my attempt to shoot the first. And that would be a felony murder. If I shot one person and the bullet went through that person and hit the other person and killed them, then the second person, I would be guilty of felony murder for that second person because it was committed during and in the course of my killing of the first person. If I tried to push somebody off a building and I ended up pushing them both off, then it would be a felony murder, or ended up pushing 2 people off. It'd be a felony murder because I have committed one murder in the course of my commission of the other. But what the state is suggesting is that if you kill more than one person at the same time, that in sequential order, that the killing of one of the first or the killing of the second is in the course of the killing of the first, which is nonsensical. And the Lynch case, the language that the state points to on pages 14 and 15, I think makes the case. Even though the state is relying on citation to a particular section, the language on their first-degree murder on page 14 reads as follows. We find no deficiency with regard to the factual proffer as it addresses Lynch's 2 first-degree murder convictions. The proffer, upon which the trial court relied in accepting Lynch's plea, provided sufficient factual support for each first-degree murder conviction. It then goes on to describe the facts. It says, according to the proffer, Lynch arrived at the victim's apartment, held the daughter victim, Leah Cadet, hostage. That's the felony. And then subsequently shot and killed both victims after the mother victim, Rosanna Morgan, arrived at the apartment. There were no deficiencies. Lynch's killing of Morgan was an intentional, premeditated first-degree murder, and his killing of Cadet was both first-degree felony murder and first-degree murder. If killing one person at the same time or in the same sequence of events as killing another person constitutes felony murder, then what the court would have said would be that the killing of both people was both premeditated and felony murder. But it only singled out one. And that's because the person was being held hostage. And that was the underlying felony. If, as the state says, the mere fact of killing someone else in sequence constitutes the underlying predicate felony for a felony murder charge as to the second person, then what the court would have said here in Lynch is that in each instance, both were both felony murder and premeditated murder. But it said it only as to one person. And that's because Cadet, who is the person who was being held hostage, is a person that was both killed pursuant to a first-degree felony murder and first-degree murder under the doctrine of transferred intent is what it says. But Cadet is the person who was being held hostage, and that was the underlying felony. It's not the sequence of murders. Once a murder is done, it's complete. And if somebody turns the weapon to another person and shoots that person, they're not shooting that second person in the course of shooting the first person. That crime has been completed, and both common understanding of English language and common sense dictates that one is not being done in the course of commission of the other. They're separate and independent acts, and we would object to any felony murder instruction under that theory, under the theory that the state advances.
Counsel, I haven't sufficiently read and digested the Lynch decision. I wasn't aware that this was going to be an issue. So as to this portion, my thought is I'm going to defer ruling right now. But before we go further, what my thought process is, I think the defense is right. So I don't know. I need to research it further and find out. But it seems to me that the way I read the case and what Mr. Howard indicated is correct.
Your Honor, you have the Pierce case as well, the state provided this morning.
Well, the Pierce case I'm familiar with. I've seen that case before and read it before. That's a little different.
And that one says that the state does not have to prosecute or does not have to allege in an indictment both premeditated murder and felony murder.
Correct.
And so that's the state's position, is that the state can then still go forward on both theories based on the Pierce case as well as Lynch. And the interesting part in the Lynch case, Your Honor, the state would point out, is in Lynch, the court specifically cites to 782.04 sub 1 sub A sub 2 sub O, murder of another human being, not kidnapping, as the predicate felony on that. And Your Honor, the state would submit that in this case, there is clear evidence that, especially with regards to the count 2, the victim Christopher Thomas, that it would be during the course of the murder of Anthony Williams, which was a premeditated homicide, that specifically with regards to Christopher Thomas, that was the individual in the backseat, that there was a defensive wound, if Your Honor recalls, that would be during the course of the murder of Anthony Williams, Christopher Thomas was then killed.
Thank you. So, Andy, I'm going to defer ruling on it. I want to read the cases. I haven't. I want to read the Lynch case over again.
We understand that, and I appreciate that. Just to the extent that the court does process the information and comes back, we would have some retort to what the state said at that time. I think now would be premature, or if you wish to hear it now.
So I wish to hear this.
Okay.
I'm just going to end up ruling on it and sending an email out.
Makes sense. Well, first of all, I'm not sure that the medical examiner, matter of fact, I am sure that the medical examiner did not establish which of the two decedents was shot first. That's one. And this issue of a defensive wound that came out of the mouth of Christopher Williams, the sergeant, contradicts the testimony of their medical examiner that said the headshot was the first shot. And so the state is trying to ride both horses at the same time. If the state has receded to the position that at least the second person who was shot, there is a felony murder charge for that person, we would take the position that the state has not presented any evidence that would rise to the level of reliability, let alone proof beyond a reasonable doubt, as to which person was shot first. The medical examiner couldn't say, and Christopher Williams had his wild speculative theories that contradict the testimony of the medical examiner as to Christopher Thomas's first shot, which is in the side of the face versus the finger. And so I don't think the state has laid the factual predicate to establish which of the two was shot first, in which case, if it's a position that they have now backed down to is, or as an alternative, I understand, is that, well, at least as to the second person, we would have a felony murder charge. Our contention is that you'd have to establish which one was, and they have not done so. Which of the two people was shot first. That's it, Your Honor. That's all I wanted to supplement with.
Thank you.
Thank you.
Defer ruling. Take under advisement. You'll hear from me.
The next with which we take issue, or maybe we should just go in order because I now have them all scrambled.
Yes, I just keep an order, please.
Yes. What would the next be?
But we had just completed in both cases, count 1 and count 2, 7.2 premeditated murder, first degree.
Yeah, I can't figure out with the supplement, but would the next in order be 3.9?
I think the next in order is the felony murder, which is I don't know, whether that's going to be given or not. I understand you object to it.
Okay.
And assuming that I deny your motion and I grant the felony murder, is there some language in 7.3 that you object to?
No. If it's, we object to it in total.
All right, so assuming that it's I disagree with you, there's no other objection as to the form of the order?
No.
The form of the instruction?
No.
All right.
Except for the gang stuff, which was previously argued as well.
Which we, yeah, the gang stuff, which we indicated goes through all of these instructions.
All right, and and that's for felony murder regarding both Mr. Thomas, the deceased Mr. Thomas, and Mr. Williams, correct?
Yes.
All right. So then the next issue that I have is 3.4, when there are lesser included crimes or attempts. Are there?
Well, Judge, I know Category 1 is second-degree murder and manslaughter. The state's only requesting manslaughter, but I believe that's requesting second-degree.
No, we're not.
So you would agree to take out second-degree murder and leave the manslaughter.
All right, so as far as the manslaughter instruction, have you seen the form instruction, Mr. Howard?
I have seen what the state has proposed.
Is there any objection to that?
No.
No objection.
Except for the gang stuff, to the extent that it exists.
All right, and I've already overruled the gang portion. That, my understanding, the law, that gang issue also carries over to the other charges. The statute itself would apply.
Yes.
So your objection is noted as to the manslaughter charge regarding the gang, but that objection is overruled, and the state's going to take out second-degree murder.
Correct. And I'll make a new 3.4.
3.4.
All right, so after the 7.7 manslaughter instruction, there's going to be two of those, one for Mr. Williams, one for Mr. Thomas, right?
Correct.
And the only objection is to the gang language, and I'm overruling that objection, so I'll allow that. So the next instruction I have is 3.5A, principles. Is that what you have, counsel?
Yes.
Any objection?
Not from the state.
It's a standard. We think that the instruction deviates from the evidence as proposed by the state and its theory, and for that reason we believe it will be confusing. But that's our only objection.
Judge, may I approach with a new 3.4?
Yes, ma'am.
Okay. Just print them all for me. One shot. Or email.
So, state which be heard regarding 3.5A principles.
No, Judge, this is standard. We charged in the indictment the principal statute, 777.011. We're alleging that the defendant and Cortlen Henry are principals to the offenses, and the evidence supports and such.
So my only question was, I thought I saw the principal instruction actually in the body of prior instructions. Was that not the case? Did I miss something? Or?
No, I think 3.5 is the... Oh, yes, it's in the felony murder. Yes, it's in the felony murder because you have to allege the underlying felony, which is the argument. So essentially you have to allege what the underlying felony was. So the underlying felony would be the premeditated murder.
Okay.
And with respect to that, Your Honor, further to our argument, they would have to name who that person is, and they can't just pick one or the other. So they have no evidence as to who was shot first, and so therefore it actually underlies and addresses our point that the felony murder, even though they don't put it in the indictment, the fact that they have to list it in their jury instructions and the underlying murder must be identified and they don't know which. It's a toss-up. Is kind of further support for the fact that it should not be included.
Thank you. So the next one I have is 3.7, plea of not guilty, reasonable doubt, and burden of proof. Is that correct?
Yes, Your Honor.
Is there any objection? That's the standard, correct?
It's a standard, Judge.
No objection.
3.9, weighing the evidence. You took out one of the paragraphs I saw.
Yes, Judge, I took out the reputation, that there was no reputation evidence, so we removed that.
Otherwise, it's the standard.
Only on this particular one, we removed accessory or informants on that, so I'm going to copy one.
So in the 1 to 10, I only removed the reputation. But on the second page, 3.9, accomplices.
I'm not hearing you, counsel. I'm sorry.
Oh, I was responding to counsel, but in 3.9, in the standard instruction, the only thing that was removed in the 1 to 10 was the reputation that I previously indicated. But on the second page, where it starts with expert witnesses, it's missing the paragraph regarding accomplices and informants, referring to Cortlen Henry.
What does that language say?
I'm going to print it.
You had previously taken it out and want to put it back in?
I missed it. Ms. Bradley and it's the standard version of it. My apologies.
No.
The big thick paragraph.
Yes. Regarding Cortlen Henry's statement that was read to the jury. And I just removed the second and third bracket, which says that he's been promised immunity or hopes to gain more favorable treatment, as those don't apply.
I don't know about that.
Okay.
With the inclusion of the language we believe to be appropriate. I think that it is entirely within the province of this jury to assume that Mr. Glass, Trayvon Fetty Glass, who testified behind the monitor and behind his dreadlocks, was here and was acting with a hope or expectation that he'll be favorably treated. So, whereas we agree that it was not established that this state attorney offered him anything, his motivation for showing up because he thought he was going to go to jail if he didn't show up, and the manner in which he testified, his entire comportment suggests that he had some ulterior motive, and I think the jury should be instructed that if that is what they found, that it is relevant to their consideration. And they may well have gleaned that just from the entire totality of the manner in which he appeared here and the manner in which he testified.
David Spielberg?
Judge, I have no objection if they want it in, so you want me to put and/or between those three brackets? Or. So for instance, the claim to have helped the defendant commit a crime and/or has been promised immunity from prosecution and/or hopes to gain more favorable treatment?
Yes, that's fine.
Mr. Howard, any other objections to that instruction?
And to that instruction, no, sir.
So, Mr. Turner, I'm going to try to work here on this. I mean, you are saying the first one, that to help the defendant commit a crime would be applicable? No.
No, we claim that is not applicable.
So it should only be hopes to gain more favorable treatment in his or her own case? Would be
Yes.
the only one that applies? Okay. So we don't need to and/or, we can just edit it to the third one? Sure.
For example, who claims,
Who has
who has.
been promised immunity from prosecution or hopes to gain more favorable treatment.
In terms of that there's no evidence of immunity from prosecution. So if hopes to gain more favorable treatment, we would agree that should stay in, but there is no promise of immunity.
We can look at it.
Okay. A witness who hopes to gain more favorable treatment. That's the only one that's, got it?
Mr. Howard, is that right?
Let me consult you. 1 second, please. Yes, sir, that's it. We're good.
Okay. For the news that we
Thank you.
The next one I have in my packet is 3.9, subsection A, defendant not testifying. That's the standard, correct?
Yes, Judge.
Is there any objection?
No objection.
Then I have 3.9, subsection B, defendant's statement. It's a standard, correct?
Yes, Your Honor.
Any objection?
We object, Your Honor, because we believe that this, I don't know, do I have to make an argument?
No objection, and I only put it in as a defendant's request.
3.9, the parties agree that it should not be.
Both sides agreed to delete it.
Yes, Your Honor.
3.9B is deleted. Then I have 3.10, rules for deliberation. Any objection? That's a standard again, correct?
Yes, Your Honor.
Any objection to it?
No, Your Honor, we would just request that in paragraph number 5, that it says your duty is to determine if the defendant has been proven guilty or not. Instead of in accordance with law, that law is beyond a reasonable doubt. So we would ask that it read, your duty is to determine if the defendant has been proven guilty or not beyond a reasonable doubt.
Statement should be heard.
Judge, this is a standard instruction. We object to any special amendments to it.
Okay. Objection is sustained. It's the standard. 3.11, cautionary instruction. That's the standard, correct?
Correct, Your Honor.
Any objection?
No, sir.
3.12, verdict. Any objection? It's a standard again, correct?
Yes, Your Honor.
Any objection to it?
It would only be, I believe, as to the third paragraph, and that is only as it relates to, because it
Depending on your rule, Your Honor's ruling.
depends upon Your Honor's ruling concerning felony murder. But if the court rules in the defense's favor on that, then that would be a paragraph that would be excluded.
State agrees.
Yes, Judge, it would have to be modified, correct?
Then I have 3.12, A, subsection A, single defendant, multiple counts, 3.12, subsection A.
No objection.
No objection from the state.
All right, parties agree with, then I have the actual verdict form, and the problem with the verdict form is, again, second-degree murder has to come out right.
Yes.
And then the issue of felony is, you see it in there.
No, because it would be an alternative.
All right. Can I ask you a question regarding the interrogatories? Any objection to those?
No, Your Honor, but before we get to the interrogatories, as to the first part, so B comes out because we're going to take out second-degree murder. And we also believe that subsection D should be subsection A. That is more consistent with the presumption of innocence. That the jury be offered the option to find him not guilty first and not last.
State have any position on it? They wish to be heard.
Yes, Judge, we might get to remain as standard in all the standard jury instruction verdict forms.
Thank you. Objection, no, it's overruled. Just leave the standard. Then I have 3.13, submitting the case to the jury. Is there any objection?
I think we're going to talk about these individual interrogatories first.
Oh, I thought you said you were okay.
No. Let me just...
Understood.
Sorry. Let me confirm.
Regarding the interrogatories on the verdict form.
No objection.
No objection? All right, so that's 1, 2, 3, 4 interrogatories with no objection. So, 3.13, then submitting the case to the jury, that's again the standard, is that right?
Yes, Judge.
Is there any objection to that?
Which one is this, Your Honor? I'm sorry?
3.13, 3.13. Submitting the case to the jury.
The only thing the state may suggest is that would say that the exhibits will be sent into the jury room with you, with the exception of any that are biohazard or anything of that nature. Those will be available for review in open court.
And also the celebrate.
Yes.
I think it's 64.
Yes. Well, and the state will provide a laptop for defense to review. It does not have access to the internet so that the jurors can review the items as they choose at their leisure, but I can tell you that the laptop the state will provide will not open the celebrate report. It's not.
Is that all right with defense? Otherwise, you know, if they want to see something, we just bring them back in here into the jury room, and counsel would have to make it available and get it up and running. Otherwise, we can send the computer back. It's up to you guys.
Could I have one second?
Can we have a moment on this?
Yes. All right, so we'll just provide the computer, let them take a look at it before it goes back to the jury, make sure everybody agrees with that.
Yes, last year on Thursday.
All right, so I owe you a ruling on felony murder. Is that it? Is that the only issue that I need to resolve?
I do believe in all related. Yes.
So I'll take care of that. I'll send out a letter, email to you today or tomorrow as soon as I resolve the issue in my own mind and finish reading the case. I mean, it's 38 pages. I haven't read it, so I'll read it and see if I can find any other cases on point. Oh, I trust you when you say these are the cases that are on point. That's it. So I'll look at that and see if I can come up with anything. And I intend to send an email out to all of you at the same time, just tell you what my ruling is. Is that all right with everybody?
That's fine. Will the state send us a finalized copy of the jury instructions?
We're going to get to that in 2 seconds. That's what I want to have happen. Whatever my ruling is, to send them a set of instructions. And I want to know if the instructions don't meet with, if you're suggesting there's some issue that we need to resolve, I want everybody back here to resolve that issue tomorrow. All right? No ifs, ands, or buts. I don't want to be arguing about jury instructions before the jury comes in Thursday morning. So I'll get an answer to you today, and it's not going to take you much time to sort out whatever my ruling is, correct, Ms. Smith? So, and then you can get a set of instructions over to counsel, and how long would it take you to review those instructions?
Probably a half hour, an hour. And we will have Ms. Liberty respond to the court if we have no objections or if we have any objections. And assuming we have no objections, then we won't meet tomorrow.
Correct.
If we do have an objection, I understand that Ms. Bradley has a commitment in the morning, so I assume we'll meet sometime around 1:30, 2 o'clock.
Correct.
Fair enough.
Is that all right with everybody?
Yes,
So just plan on being here tomorrow at 1:30, unless counsel, Mr. Nielsen, did I say it right?
It doesn't matter, Judge. You can call me.
No, I apologize. Adelstein. Mr. Adelstein, if I hear from you and you send out an email to the state as well as to the court, let us know, let's say by 1 o'clock, is that all right? Whether you're going to be here or not?
1 o'clock today?
No,
Tomorrow. Yeah, 1 o'clock tomorrow. If we have to be here, it's fine with us.
You say let's notify.
Notify the court by tomorrow.
By tomorrow, 1 o'clock.
By 1 o'clock.
Otherwise, be here at 1:30.
Fair enough.
Is that good with everybody? Was there anything else?
I'm just going to approach with the amended verdict form.
All right, you're going to send assuming whatever the final version is, you're going to make copies, correct?
Correct.
And for the copies, though, I need one for each of the jurors.
Correct.
That's 14. I'm going to need one for the court reporter, is 15. How many does this defense need?
3.
18. And we need an extra one, right? 19. So let's say you make 20 just to keep a round number of it, so there's no issue if something gets wrong. Now, regarding the closing argument, I don't see how this is going to work in one day with a 4-hour closing, respectfully. I don't see how it's going to work. The jury, Gary, when I talked to Tom, he explained to me that the jury was instructed to be here on Thursday morning at what time?
9 o'clock.
9 o'clock. Where at?
First parking garage.
The parking garage. And then you got to bring them over here?
Yes. We'll escort them here.
You'll escort them
They'll
here?
have a designated area. There'll be deputies there waiting for them, and then we'll escort them.
And how long does that take?
Assuming they get here at a reasonable time. And they're
Assuming
not,
they get here on time. I know we've never started on time because we
they'll
always
have to put everything through the scanner, their luggage and everything. So I would say 30 minutes.
So assuming we start at 9:30, and I think that's a big assumption. My guess is we start at 10, all right? Because we've told the jury to be here, and there's always somebody who's not showing up at 9 o'clock, always late, and by the time we resolve whatever issues we have, we start at 9:30. And that's, that's just the nature of the beast, so to speak. But assuming we start at 10 o'clock, and you go 3 hours as we're closing, without taking any breaks, you're going to be into 12:30, quarter to 1, and your opening argument. We take an hour or so for lunch, come back, at, let's say 2 o'clock, and defense puts on their argument. There's no way we can finish all this. There's just no way. And we indicated, you all told me you wanted to do it in one day. It just, there's not enough time to do it because the first night they have to be out of here by 5. They come, they have to make arrangements to get them out of here by 5 o'clock. They've asked me to assure them because they have to make arrangements over at the hotel where they're being sequestered at, things like that. Friday, they'll pick them up. They're working on all those arrangements, and they'll be over here to start their deliberations Friday morning, and they'll get them over here fairly early because they'll have them. They've all had breakfast arranged already. They're working on all of that. So my thought is, you can't have 4 hours. It's just not going to work. You can't have 4 hours. If you go 3 hours, put an opening 2 hours, rebuttal an hour, that gives Mr. Alstein 3 hours, and I don't know who's doing the closing. Who's doing the closing?
I am.
So that gives him the time in the middle, 2 to 3 hours. Because whatever I give you, I got to give him.
I understand.
And then you have an hour for rebuttal. I don't know if you really need an hour for rebuttal, but the problem is it's cutting really, really close to that 5 o'clock time. That's the problem I have.
So you're saying even asking for 3 hours would be too much? Is that what you're...
No, I'm saying I think we can get it done in 3. And again, I have to hold out the same time for the defense as for you. But counsel's indicating to me he doesn't think he's going to need 3 hours. But if things change, he's entitled to the same time that I give you. But if I give you 3, and we started, be optimistic, we start at 9:30, all right? 9:30, 10:30, 11:30 is your opening argument. Okay, we got to take a break in there someplace. It's going to take me a half hour to read the instructions. So you'll probably be done with your opening argument if you take 2 hours somewhere around noontime, 12:15, 12:30, something like that.
So is it your Honor's intention to read the instructions to the jury first and then closings?
That's what I typically do.
That's fine. That's fine. The state has no preference on that.
Because you're going to use the instructions I thought in closing.
Yes.
And, so I would...
I'm sorry. I have no problem with them using the instructions before you read the instructions since we have them. So may I suggest considering starting closing arguments immediately, because at least if we run out of time, the court can instruct the jury Friday morning. This way, we're assured that closing arguments will in fact be complete on both sides. And if we agree to the jury instruction, then I see no harm in either side using those instructions.
My understanding from the rules are you can do it either way. So up to however you want to do it. So I leave it to the attorneys basically. You tell me whether you want to read it first or last. I typically read it first. Not my preference. That's just what the attorneys want me to do typically. So I don't really care one way or the other. You tell me how you want to handle it. That's number one. But if we do 3 hours, just talking about the time frame, if you do 2 hours and you get your closing done in the morning, let's say, we take an hour and 15 minutes or so, that's what we've been doing for lunch, come back, Mr. Alstein can have his 3 hours thing, and then you come in for your 4th hour at the end, and it should be, if he takes the time, he's telling me he's probably not going to use the time, but he's entitled to it. That brings us up right around 5 o'clock.
Yeah, I will, if you're instructing us to do 3 hours, I will do my best to get everything done in the 3 hours. I'm doing it 2 and 1. So if it might go over a little bit, it might be under a little bit. So I don't write it out word for word.
I would ask you to do the instructions last, since we agreed to it, and in the event that we're running late, then...
Stop you for a second, Gary. What happens if we're running over a half hour on these things? Because Tom says you got to get them out of here at 5 o'clock.
I don't
I've
think
never had the issue come up.
Yeah, I don't think it's such a big deal. I can check with him to see what's the latest. I know the first night is kind of lengthy because the things we have to do before we take them there.
All right, so we'll see how it goes. I'll get your ruling hopefully today on the felony murder issue, and then we're going to meet back here 1:30 tomorrow, unless I hear and you hear from defense counsel that they're agreeing to the instructions preserving your objection. But I mean the form and substance of the changes that we made, they're in essence agreed to conform to my ruling. And otherwise, everybody meets back here at 1:30. Okay?
So the only thing I could think of to deal with or address prior to the closing is if defense is going to object every single time I call the phone number of the defendant. If we have as opposed to having to argue that every single time, if the state makes sure, now argument in the state has proven that phone number belongs to the defendant.
I think she has the right to refer to it as the defendant. I also have the right to argue that if I so choose that they haven't proven it. But I think at this point that's fair comment on the testimony.
And that's what argument is. It's comment on the testimony. You're the way you're receiving it. So I doubt there would be an objection. But counsel just telling me that that's it's a threshold question in the trial as to whose cell phone it is. And that's why you asked to let all those emails and text messages and all that kind of stuff in there.
But that was one of the reasons I was asking for 4 hours because I anticipated a lot of objections on that specific area.
We're not going to object to that. She's entitled to make that argument. Your Honor, there's just one thing remaining, and we're not sure that we know we made a motion for judgment of acquittal at the conclusion of the state's case in chief, at the conclusion of the defense case. We are renewing it at the conclusion. I guess the state didn't put on a case, but just in case there was any procedural requirement that we do so in order to preserve our rights, we are renewing at the close of the state's non-rebuttal case our motion for judgment.
I thought you did, and I thought you did that earlier today, but if I'm mistaken, I'm sorry. But you said, I thought the last time there's no other argument, you're standing on the arguments you previously made. Is that correct?
Yes, sir, correct.
And the state have any additional arguments?
Just from the Lynch case, Your Honor, I would also cite as to the premeditation aspect, there's case law on that as to how premeditation can be proven.
I'll defer ruling on it, and I want to read the case over, and I intend to get you an answer today. If not, it'll be first thing on Monday.
Yes, sir.
All right?
Thank you, Your Honor.
Judge, I spoke with Tom, 5:15 today.
All right?
So I would again, based on that, ask the court to instruct the jury last.
Well, I think the state has no objection to it.
Oh, okay, fair enough. I missed that.
I'm going back and forth on that one. I'll think about that and we can discuss tomorrow. I prefer the court to have to read the instructions first on that so that that's the baseline and that's already been given from the court. So.
Typically, that's the way I do it, but it's discretionary. It can go either way. See what the issues are. And my only concern is making sure we get it done. But I don't want to, instructions are important. They're going to have a hard copy of the instruction, but I don't read these instructions really fast. I take my time reading it. I'm not going to just fly through it. I just don't do that.
And we're asking that it be read last. So we're clear on that.
I understand. I want to hear what the state has to say. She says she's going back and forth. And I do understand that discretionary is up to the courts.
Go forward.
Okay? All right.
Yes.
Anything else to discuss?
No, sir. Thank you very much.
How about you, ma'am? Anything else to discuss?
No, Your Honor.
See everybody back 1:30 tomorrow unless I hear from you.
You're going to hear from the designated person that Judge Siegel's appointed, and that is Miss Liberty, with all due respect.
With all due respect, I'm sure that Judge Siegel didn't appoint any one of these.
Oh, yes, he did.
Lawyers.
He did. He did. He absolutely did.
I disagree with Mr. Allison. That is not my recollection of how that day went down.
Washington, D.C., as well as criminal defense attorney and civil rights attorney Tyler Bailey. He's down in Columbia, South Carolina. Gene, I want to start with you. So the defense rested, put on one witness. I think many people thought that the defense would have a more lengthy or robust case, but they put on one witness that arguably may have created the reasonable doubt necessary to get an acquittal. But what are your thoughts?
Well, I'm a little at a disadvantage here because I didn't get to see that witness. But just looking at it optically, if you call one witness, and it's not quantity, it's quality, and that one witness raises a reasonable doubt, you're going to pound that in closing. And you're going to say, listen, the government put on this parade of witnesses, gone off at tangents, talking about gangs and Facebook videos and all that. We called one witness. But that one witness was all we needed because it raised reasonable doubt. And if you have one bit of reasonable doubt, not guilty.
No, absolutely. And Gene, I'm going to fill you in. In a nutshell, that witness, who was YNW Melly's friend for many years, came into court and said that YNW Melly was in a red Mitsubishi, a different car, at the time the news came down that the two deceased were shot. So arguably, just in a nutshell, that YNW Melly was not anywhere near that car when those two individuals were shot. And although the prosecution are going to point out some credibility issues with this witness, the sort of bias, maybe the fact that they were friends for many years, and this is sort of testimony of convenience, if you will, coming in now, based on that, and you said exactly the points that we've been talking about, that, a strong piece of evidence for the defense may be just enough to raise that one piece of reasonable doubt enough to get an acquittal. Based on what I just told you, do you think that that's going to be something that the defense will be able to successfully argue at the end of the case?
Well, whether it's successful, I'll have to wait for the verdict, but it's definitely an argument you're going to punctuate and pound. And the more I think about it, because it's just one witness and it's classic reasonable doubt, it's not a gratuitous witness. If he's in that other car and they believe that he was in another car, then it's game over and he wins. And I got to criticize the government a little bit. In my opinion, their most powerful witness was that accident reconstruction or murder reconstruction guy that was talking about the bullet angles and all that. That should have been their last witness. But last week they had a couple other extra witnesses where they got into videos and all that, and they were distracting. And the jury, to me, I didn't need to see their faces on the TV. I could tell they were bored. So the defense was very smart to just add this one witness, one witness only, and they better pound that in closing.
Yeah, and I want to get your take, Tyler, on the same question. The defense puts on one witness. There was a voluminous amount of evidence that the prosecution put before this jury, a lot of forensic evidence, but now defense puts on their case, one witness. It's a fact witness that testifies about what we just spoke about. Do you think that this was a good strategy on the side of the defense in terms of putting on their case?
I think it's important for people to remember that the defense does not have to prove anything. The state bears the burden. They're required to prove their case beyond a reasonable doubt, and the defense is not required to even put up one witness, but they did. This one witness, I think, was a great one for the defense, who testified that Melly was not in the Jeep and he was rather in the red Mitsubishi. Now, whether his credibility is going to be received well by the jury, we'll find out when they issue their verdict. But I think it was a good strategy. The defense this entire case has been attacking all the state's witnesses. They also got some good testimony out on one of the state's witnesses about there being threats to get certain witnesses to testify. I'm pretty sure they're going to harbor on that during their closing arguments. And then they'll talk about their witness who's saying that Melly was not in the vehicle. Showing the state's case is pretty much all circumstantial evidence. There's no gunshot residue evidence. And now with this testimony that Melly was in another vehicle, it's a pretty strong ending for the defense's case, if you ask me.
Yeah, Tyler, I agree. Tyler Bailey, Gene Rossi, great analysis. And you stick with me. We're going to be talking a little more about this later in the show. But right now we have to take a break here at Law&Crime. When we come back, more trial coverage of the YNW Melly trial in Florida. Stay tuned.
100% sure that this young man got into the red Mitsubishi?
Yes.
What happened to the Jeep?
I think they just kept going.
Did he have to unlock the door?
Yes.
Do you know who has the keys to Melly's house on October 26th in the early morning hours?
Jamell and Bortlen. They're the only one who had keys to the house.
Okay. Did you have a key to the house?
No.
Did Williams have a key to the house?
No.
Did Christopher Thomas have a key to the house?
No.
Did Trevon Glass have a key to the house?
No.
Did Jacoby Mills have a key to the house?
No.
And how about Dontavius Williams? Did he have a key?
No.
Okay, so the only two people you know who had a key to the house was this young man.
Yes.
And Cortlen Henry.
Yes.
Did you see this young man unlock the door of the house?
Yes.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon. He was in the car still asleep.
He was in the car asleep when you got to his house?
Yeah.
Mr. Davis, you said you're 100% sure that Mr. Demons found out at the same time you did?
Yes.
No questions about that? You're sure he was at that house?
Yes.
And you were upstairs?
Yes, ma'am.
He was downstairs?
Yes.
But you're sure he was there? You could see him?
Mm-hmm.
Is that a yes?
Yes.
And you are 100% sure his phone was missing?
Yes.
Where in this statement on May 5th did you ever say that?
Objection.
Suggestion.
It was never asked.
Thank you. Counsel, so I guess the objection is improper impeachment, so rephrase your question.
So, you met with me on May 5th, 2022, you remember that?
Yes.
And you remember sitting down, you were present? That's a yes?
Yes.
Your two attorneys were present that you brought? That's a yes?
Yes.
And I asked you questions for quite a number of hours. Do you remember that?
Yes.
Okay. And do you remember being asked if you had met with anyone else with regards to this case?
Yes.
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
Yes.
Okay.
I didn't know who they were, and my lawyers told you that.
Okay.
I didn't know their names.
But you remember meeting with them?
Yeah.
Okay. And do you remember asking and being asked a question about what you talked about with them?
Yes.
Did you remember what you told them?
No.
Do you remember what you told them now?
Yes.
So are you telling this jury that when you were speaking with me, you forgot?
As in, what I'm telling them now, as of right now, yes.
So do you remember that evening driving to the studio?
Yes.
You remember who was in which car?
On the way there, yes.
And you remember who was on each car on the way back?
Yes.
Okay. Are there any threats that were made to anyone that night?
No, ma'am.
Did anyone have any other conversations or discussions about threats from outside parties?
No, ma'am.
Is anyone worried about their safety?
No, ma'am. But Melly's a rapper, you know, he's always going to be a target.
I'm sorry.
I said he's a rapper, so he's always going to be a target.
Okay. And do you remember stopping on the side of the road?
Yes.
Where did you stop?
I don't remember. It's like flashes and blinks, drinking and smoking, so I just know we stopped.
You know you stopped.
Yeah.
And do you remember if that was on a highway?
Not at all.
Okay, do you remember if it was on a divided 4-lane road?
No, ma'am.
Do you remember if you guys were using GPS to get home?
No, ma'am.
Okay, do you remember if you knew the route home?
No.
Okay. Do you remember what phone number you had back then?
No, ma'am.
You don't remember your phone number?
5 years ago, so.
Okay. Do you remember if you were awake or asleep?
I just told you. We were asleep.
You were asleep. And you said you were intoxicated?
You didn't answer out loud.
Yes.
Do you know why the car stopped?
No.
Do you have any conversations or messages with the defendant?
No, ma'am.
Do you have a phone call with him?
No, ma'am.
When you stopped, was the gray Jeep in front of the red Mitsubishi?
Yeah, I believe so.
Have you ever answered that question differently?
I don't think so.
If I were to show you your statement from May 5th of 2022, would that help you in answering if you'd ever said something different than what you just testified in court?
Yeah, probably.
Okay, approaching with page 33 of this statement, counsel. And you just read silently to yourself.
Yeah. I basically told you I don't remember.
Okay, so now your answer is I don't remember if the Jeep was in front or the Mitsubishi was in front.
If we watched the video, they put off first, so.
Okay, Tyler Bailey and Gene Rossi joining me right now to break down some of this testimony that we heard today on the defense case. Tyler, I want to start with you. Let's go to the first clip that we saw of the direct examination from the defense. The witness testifying to rather passionate questions from the defense that he's 100% sure that YNW Melly was in that car with him and with him when the news about the shooting was received. Do you think that was an effective presentation to the jury? And do you think that testimony is going to be something that's going to resonate and perhaps lead to an acquittal?
Well, it's the defense's entire case, which is that Melly was not in the vehicle. He was not in the Jeep at the time of the shooting. Whether the jury is going to believe this witness is another question. I do think there are some things going against his credibility. He has a long-term friendship with Melly. That's understandable given that they're all studio and aspiring rappers or rappers. But then you also have that on May 5th of 2022, this statement wasn't given to the state. I think that's going to probably hurt some. So the jury's going to have to determine whether they're going to believe the defense's narrative, which is that Melly was not in that vehicle, or they're going to believe the state's case. I like it because it's a clear yes or clear no. It's a clear decision for the jury to make, but it all hinges on the credibility of this witness. The defense, like I said earlier, attacked the credibility of state's witness during their entire presentation of their case, but their case wholly relies, I believe, on this witness and whether he's going to be believable or not to the jury.
Yeah, no, Tyler, I 100% agree with you, and I think that the prosecution tried to bring out some of those credibility issues in their cross-examination. So, Gene, let's go to the cross. You saw a clip of the cross-examination by the prosecution of this witness pointing out to some credibility issues, pointing out also that he was asleep and he was intoxicated, he was high. Do you think they were able to successfully discredit his testimony?
I think they were able to say in closing that he has some inconsistencies and that the May 5th, 2022 statement had some omissions and inconsistencies that attacked the credibility. But I want to go to what Tyler said. Jurors like simplicity. They don't like complicated cases. They like it cut and dry, black and white, yes or no. And this witness provides that yes or no, black or white issue. And if they believe this witness, if they believe him, then Mr. Demons is innocent. Game over. It's a simple proposition. Did they get some credibility points, impeachment points in the cross? Yes, it was a little, disjointed at times, but she did get some hits out. He met with the attorneys for Mr. Demons before the statement was made. That's the way I understood it. That goes to his credibility. He's friends with him since they were essentially young kids. That goes to credibility. So both sides have a lot to argue, but Tyler's right. Yes or no, simplicity is something that jurors love.
Yeah, I agree. Sometimes you want to keep it simple, stupid, and keep it short and sweet. and that's what's most effective at trial and what resonates with the jury, and especially so because you saw the prosecution really having a voluminous amount of evidence that at times you got the sense that the jury may be a little lost because it's just sort of meandering testimony. But we will wait and see how the prosecution brings it all together on their circumstantial case in summations, and of course how the defense then hits it home in their summation. But we're going to take a quick break here at Law and Crime. When we come back, more coverage of the YNW Melly trial in Florida. Stay tuned. Welcome back to Law and Crime. I'm Imran Ansari, and we continue to follow the YNW Melly double murder trial down in South Florida. Court is now dark until Thursday when closing arguments are slated to begin. But I want us to recap some of the arguments that were taken outside of the presence of the jury that happened earlier today as the defense wanted to introduce more evidence in front of the jury. Let's listen how that played out.
Is counsel the assistant state attorney. My understanding the jury's in the jury room, is that correct?
Yes.
All right. So, counsel, I want to verify is what's going on now. My understanding from yesterday is that you have two witnesses this morning and relatively short that's still on track for that.
I believe so.
And the state,
I don't know how long the process is.
Understood.
Yes, sir.
And the state indicates they may have one rebuttal witness, correct?
Potentially, yes, Your Honor.
All right. So, and everybody will be ready this morning. So, how are we handling Wednesday? What was the verdict with Judge Fine?
We're going forward to accommodate the defense's other scheduling conflicts. They're pushing us back to the last week of August and then into September. So I indicated maybe a conflict with this case for a second phase, but he was hoping that we'd finish the third and second phase by that point.
So let me ask you this. So going forward tomorrow, what's the time frame of your requirement? The whole morning?
The morning until we get 60 potential jurors that are available for those weeks.
So when we talked yesterday, he was off the record informal about what was going on with the schedule. My understanding was both sides wanted to have it where the closings all one day, correct?
Yes, sir.
All right, so then if we're not in session Wednesday, all right, we just won't be in session on Wednesday, and we'll come back to all the closings Thursday, and that's enough time to get both sides done, correct?
Yes, sir.
And then, so Tom, that's why Tom's here, he just wanted to verify the schedule, so he has to get the jurors for sequestration on, prepared for that.
There's one issue we need to discuss before we start. The state introduced a video of our client, a portion of the video of our client that he did the afternoon of October 26th. I don't know what exhibit number.
No, it was 4 days before.
Oh, 4 days before. I'm sorry. I don't know the exhibit number. They played just a portion of it. The court said to get rid of the portions with the guns. And they played a portion of it. We, in fact, gave since it's in evidence, we gave a copy of the edited total video, excluding the guns pursuant to the orders of the court, and would like to play that entire video from start to finish with the edited portions dealing with the guns out. And I know the state has reviewed that to confirm that the guns were edited out.
So it's clear, the state is objecting to the full rest of it coming in. It's just basically a promotional video for the defendant's mother and grandmother. There's statements by them that are in there that would not be admissible. All the statements of the defendant are self-serving. They're intended to elicit sympathy as to his upbringing or anything of that nature. He admits to committing an arson of a forest in it. They left that in. So, Your Honor, it's completely self-serving, and for the purposes of sympathy, there's nothing on the issues in this case. It was introduced to limited portions of the state to show that the defendant had put out a statement indicating he was a victim of a drive-by and placing himself, based on that documentary, which was released in December of 2018, that he was a victim of a drive-by shooting.
Is that correct, Mr. Edison?
Mr. Howard would be able to.
Sure. Is that correct?
As to what the state's purpose for putting that in was?
No, as to what's contained in the rest of the video.
Oh, well, it's a documentary. Now, if there is a portion concerning arson of forests, we would take that out as well because we wouldn't want that in there. I didn't notice that to exist. But essentially, it's a documentary that the state introduced in order to demonstrate that Mr. Demons claimed it was a drive-by. It was a promotional documentary that was put out by his label, not by him. So it shouldn't have been introduced for that purpose because it's misleading as to attributing the statement at the end of the documentary to Mr. Demons. But beyond that, we think for sake of completeness, what the state did was edited portions that they wanted to put in, and we're asking to put the rest in absent any improperly prejudicial portions. And we'll take a look at it again to the extent that there's any reference to a forest arson. I missed that entirely, but we would be taking that out as well.
How long is the tape?
I think the total was a 12-minute documentary. The state put in about 2.5 minutes of it, and with the edited portions, it's probably around 8 minutes or so.
Well, this, you have it here so they can play it?
It's here. They have played it. They've seen it.
All right, so why don't you play it for me?
Sure. I don't know. But yeah, we would certainly be removing any arson admissions that we overlooked.
The defense was trying to get in before the jury in total. The judge ultimately denied that request, and the defense was not able to show the totality of that video. But we're going to take a quick break here at Law and Crime. When we come back, more coverage of the YNW Melly trial. Stay tuned. Welcome back to Law and Crime, where we've been covering the YNW Melly trial out of South Florida, Broward County. Court is done for the day. They're going to reconvene on Thursday for the summations of the prosecution and the defense. The defense put on a case calling one witness today and then rested. So we are now waiting for summations on Thursday. But in the meantime, we've been looking at some clips from court and recapping. Let's bring in my two great guests to talk about some of the things that we saw in those clips. I have former federal prosecutor, criminal defense attorney Gene Rossi down